Feeling better today, Mr. Potts?
Slightly, yes, thank you.
Good.
Good morning. I now call Mr. Shalab.
Yes, of course. Yes, sorry.
Will you be swearing in on both microphone? Would you like the Quran?
Yes.
Thank you. Can you please confirm your name and occupation for the court's record?
My name is Mahmoud Shalab. I'm the head of Mali Innovation Department in Buhaira Insurance.
Please repeat after me. I swear by the Almighty God
I swear by Almighty God,
that I will say nothing but the truth.
I will say nothing but the truth.
Thank you.
Please do sit down. Thank you.
Mr. Shalab, I hope that you have a thin file in front of you.
I'm not sure if anybody can hear me. It's the transcriber. If Mr. Craig could put his microphone near him.
Oh,
Thank-
is that better?
Thank you.
Mr. Shalab, if you could take that bundle and turn to page 270 in the top right-hand corner.
200. Yeah.
You should see a document which is headed First Witness Statement of Mahmoud Hassan Mahmoud Shalab.
Yes, that's correct.
If you turn in that statement to page 276,
Okay.
you should see a signature.
Yes, that's
Is
correct.
that your signature?
Yes.
And is this your witness statement?
Yes, that's mine.
And do you confirm that its contents are true?
Yes, I confirm.
Thank you.
Thank you.
Good morning, Mr. Shalab.
Good morning.
My name is Mr. Potts. I'm going to ask you some questions.
No problem.
Microphone on. My name is Mr. Potts. I'll ask you some questions. Mr. Shalab, you've described yourself in your witness statement as head of marine and aviation underwriting and claims at Al Buhaira. Have you always held that job title?
Yes.
When did you first receive that job title?
When I joined Al Buhaira Insurance.
So that was in 2012, is that correct?
Yeah.
Can I ask you to look in the bundle, please, at page 367?
Okay.
Do you see there at 367 a document which is headed Organisation Chart?
Yeah.
Are you familiar with this document?
Yes, I'm familiar. Yes.
Do you know when this document dates back to?
No, I don't know.
Okay, I'm going to suggest to you it's from 2019. Would that surprise you?
No, it's not surprising.
Okay. If you look at page 367, can you see that the board of directors are in the box at the top of the organisational chart? Do you see that?
Board there, yes.
And the board of directors are the senior management of Al Buhaira National Insurance Company. Is that correct?
Senior management, yes.
And then just below that, you see the audit committee on the left and the nomination and remuneration committee. Are you familiar with those committees?
No, I'm not familiar.
You're not familiar with them. Now, beneath the board of directors, you see the managing director, and then beneath that, the general manager. You're not either the managing director or the general manager, are you?
I know that.
So do you know who was the managing director in 2018?
2018, yes.
Who was it?
Mr. Shafal.
And the general manager was Mr. Kadumi, is that
Yes,
correct?
that's correct.
And Mr. Kadumi is still the general manager today.
Yes.
Is Mr. Kadumi available to give evidence in this trial?
I don't know.
Do you know why he's not giving evidence in this trial?
No, I don't know.
If you look further down the page 367, can you see, if you go down, there's technical departments
3, 6,
on the right, and then it leads down the chart to risk management, reinsurance,
Mm-hmm.
life, medical, and then on the right, general insurance, fire and GA,
Yeah.
marine and motor. Is that the box that you fall into?
Yes.
And then further down on the left, there's a legal department.
Correct.
You have nothing to do with the legal department.
No.
If we go over the page, please, to 368, can we see the names of the directors who are on the board of directors? Can you see the name of Mr. Abdullah Juma Al-Sari?
I can't see his name, yeah.
Do you know Mr. Al-Sari personally?
Personally, I don't know him, yes, but he's our board member.
Sorry, I didn't quite hear that. Did you say you don't know him
No,
personally?
I know him. Personally, I don't know Mr. Salim, but he's our board member.
He's a board member. So you've never met him in person?
No.
But you can see from the chart that he was chairman of the audit committee on the left, and he was also chairman of the nomination remuneration committee on the right. Is that correct?
Yes, but I have no comments on this.
You had no comments on it. Does it follow, though, that as chairman of the nomination remuneration committee, he was responsible for deciding the remuneration of all employees at Al Buhaira?
Can you please repeat?
Given that Mr. Al-Sari was the chairman of the remuneration committee, wasn't he in charge of deciding all compensation and remuneration for all employees at Al Buhaira?
I don't know about this.
You don't know that?
No.
So when your salary is reviewed every year or you're paid a bonus, you don't know that it's Mr. Al-Sari who was in charge of that?
No, I don't know. I am, because I'm reporting to our CEO.
Okay. Isn't it true that you report to Mr. Kadumi?
Yeah.
Yes?
Yes, true.
So if we look, please, at page 369, you'll see the way that the chart is structured here at 369, that Mr. Kadumi is at the top as the general manager,
Yeah.
and then we have various committees beneath that, which lead down at the bottom in the middle to Marine Insurance Department.
Yes.
And again, that
correct.
was your department. And if we go over the page, that's then sort of, there's more focus on that particular bit of the structure at page 370. Can you see on technical departments, at the left, there's the Marine Department,
No.
and in the box Marine Department, there's the words or the name Mahmoud S. Now that means you, that's Mahmoud Shalab, isn't that correct?
Yes, that's correct.
And there, your job description is Marine Manager.
Yes, that's correct.
So you weren't described in the organisation chart as of the head of Marine Underwriting and Claims, were you?
Oh, no, not described, yes.
And that's because your job title at the time was actually that of Marine Manager.
Yes, Marine Manager, yes.
And in fact, the person who's really the head is Mr. Kadumi.
Can you please repeat head of what?
Well, the head of Marine Underwriting and Claims, the person with actual underwriting authority, is Mr. Kadumi.
No, not Mr. Kadumi.
Okay. Can I ask you then, look, please, at page 418. Page 418. Can you see at page 418 a document headed Marine Hull War Policy Schedule?
Yes, I can see.
and that has a policy number SH Hull 000114/15/SF. Do you
Yes.
agree?
Okay. Yeah.
Can I ask you to look, please, at page 420? Can you see the authorised signature field?
I can see this.
That is the signature of Mr. Kadumi, isn't it?
Yes, correct.
It's not your signature.
No.
And the stamp that's been applied on behalf of the Marine and Aviation Department, that's a stamp that's applied by Mr. Kadumi, isn't it?
No, it's not Mr. Kadumi's stamp, it's our stamp. The department.
So who applies that stamp?
Marine department.
Who in the Marine Department applied that stamp?
Our staff.
Your staff?
Yeah. Which means the same people in the same department.
Okay, now if you look at the bottom left, can you see some initials that are scratched there?
Yeah.
Do you know whose those are?
Yeah, that's my initial and my colleague.
Which colleague?
He is in the department, other than.
So essentially what's happened, and you see the same signatures 2 pages earlier at 419 and 420.
Mhm.
What's happened is that you have been responsible for putting this policy schedule together, is that correct?
Yeah.
And then once you put it together, you've signed it at the bottom left, and somebody in your team has countersigned it, and you've applied a small stamp. And then you've delivered it to Mr. Kadumi for him to give his authorization and approval, and then to sign it on behalf of Al Buhaira. Is that correct?
Yeah, that's correct, because he is authorized to sign this over my limits.
You were not authorized to sign this.
Because this is we have limitation, you know.
So at the
This
time,
policy exceeds my limits, so it's go to our limits.
okay, so at the time in 2015, what was your personal authority in terms of signing off on a insurance policy?
It was up to 20 million.
Up to 20 million.
Yeah.
But in this case, the facultative placement was for almost 400 million,
Mhm.
and we're talking dollars, I assume.
Sorry?
Do you mean $20 million or 20
No,
million dirhams?
dirhams.
20 million dirhams.
Yeah.
So 20 million dirhams is about $5 million. Or?
Yeah. This is my authority.
Okay, so your authority was $5 million, 20 million dirham, and the actual value of this policy that you're underwriting was $379 million.
Yeah.
So way beyond your authority.
No, it's not about that. There is limitation categories. So allow me just to explain. So each policy it has its limits. So whenever anything exceeds my limits, it will go for, let's see, he has no limits. He can sign up to whatever, any amount.
Okay.
But any preparation will be done from my side.
Now Mr. Kadumi, do you know, I appreciate you're not him,
Of course.
but do you know if he knows Mr. Al-Sari?
Of course, you know, yeah.
Of course he knows him, because the general manager and the board of directors interact frequently. And just so I understand it more clearly, if we go to the 2018 war policy, which you find in the bundle, please, at, I think you'll find this at page 488. Can you see 488? That's the Marine Hull War Policy Schedule.
Yep.
Can you see the reference for that is SH Hull 000114/18/SH?
Yes, I can see.
Do you know why it has a different reference number to the 2015 policy, which seemed to end in SF?
Of course, it has different number.
Sorry?
Every year it has different number. It's not one policy just to renew every year, no.
Well, doesn't it have a different number for the year in the digits that just precede the letters? So 18 refers to 2018.
Actually, the last, you are talking the last digits as such. It's what we need to know. You are talking about the last digits, 2 digits? I mean the two.
Yes. So just when we looked at 418 for the 2015 policy, the numbers were SH Hull 000114/15/SF.
Okay.
And the point I'm making is that the 15 is referring to the year 2015. Isn't that correct?
Yeah, but it has different category. Every year it has different category. The last two is the reference to the agent name, agent code. The last two digits for the agent code.
The agent code.
Agent code, yeah.
What do you-
SF means different code, SH is different code. The agent name and code.
The agent
Code,
c-
code.
c- Can you explain what you mean by the agent code?
Agent code means SH refer to like SH Shalab for me, like belongs to Marine Department. SF that time it was like for different agent.
So who was SF?
That is I think our CFO name.
Your CFO was SF.
Yeah. That is for the purpose only just for collecting the premium. That's it.
Okay. So there's a difference though. Does that suggest that somebody different was involved in 2018
No,
policy?
it's not about different. That is only just for code. Has nothing to do with the policy terms.
Okay.
Just only number. That's all.
Can you look please at page 490? Can you see there that it's Mr. Kadumi who's signed as the authorised signatory?
Yes, I can see.
And whose signature is at the bottom left?
Mine.
Yours. And if we just look at the hull and machinery policy, were you involved in that?
Yes.
Can I ask you to look at page 506? And if you want, you can look at, well, please look at 504 to start with. Are you familiar with this document, 504?
Yes.
And this appears to be a copy of the hull and machinery policy for 2018.
Yeah.
Can you see the policy number there is SH Hull 000-113/18/SF?
Yes.
Why was that SF and not SH?
That's what I can explain you. Let me start from the left side. SH means head office, which the code
Head office Sharjah.
Yeah. HAL means the type of the cover. Okay. The number, this one is a serial number generated by every year, depend on which number, which policy. The same policy, it is not renewing by the same policy will be renewed, the same number, no. Every year it has different number, okay? 18 means the year, which the year that the policy issued, and that stuff is the agent code.
So does that
That
mean
time the policy was under that agent for in terms of collecting the premium.
so there's a different agent handling the hull and machinery policy?
It's not handling, no. Just I'm telling you, only just SF, just to collect the premium. Handling, it's technical department handling. Just for clearance.
Can I just clarify? When you say agent, what do you mean by agent?
Agent means when you open any account for any policy, there is one agent code has to be in there. In
But
that policy.
yes, so when you say agent, an agent is an employee of the insurance. It's not an external agent.
No, it's an employee of the insurance company. Yeah. Salesman, let's say, not agent.
Yes, it's not. So it's not like a broker.
No, no, no.
No. Okay.
Thank you, my lord. So within the Al Buhaira Marine Department, I didn't catch it earlier, I'm sorry. The individual whose initials are SF, what was that? The name of that employee?
It is Salah Daw.
Sorry,
Mr. Salah.
Mr. Salah.
Salah, yeah.
Was it the gentleman who gave evidence yesterday?
No. Salah means CFO. It's our CFO currently.
The CFO.
Yeah.
But did he also work in marine underwriting?
No, he's in the accounts.
He's in accounts.
Yeah.
Why would he have had any involvement in marine underwriting?
He's not in underwriting. I will explain again. He's in the accounts department behind the collecting the premium. So this policy will be like whatever anything outstanding, it will be referred to him. He will be the one who is handling this one. This kind of policy in terms of premium collection.
Was it because his was the client relationship, or the client he generated some
I
internal?
don't know. This is something I don't know.
He didn't generate internal credit or take credit for having a client that brought in so much premium.
No, that's I don't know.
You don't know. Okay. But in any event, what we can see is that across all these policies, it's Mr. Kadumi who's signing, because Mr. Kadumi was the individual who had the underwriting authority to underwrite these policies. Is that correct?
Not to underwrite, just to sign the policy and to his level.
Well, I think underwriting means writing your name under the policy.
I didn't get you. Can you please repeat?
The word underwriter
Yeah.
in English is often used interchangeably with the word insurer,
Okay.
but the reason the word underwriter is used because it's referring to the person who underwrites the policy. And by that I mean they write their name under the policy. So in fact, the underwriter here is Mr. Kadumi, isn't that correct?
No.
I think the confusion, I think by underwriter you mean the people within the underwriting department who actually set the premium when they look at the risk. Is that what you mean by underwriter?
Yes, the underwriter means the
But
people.
what counsel means is the person who has authority to sign.
Yeah, the authority to sign. Yes, is by our CEO.
Yes.
This is the correct.
So Mr. Kadumi is the person who had authority to sign.
Yeah.
Thank you, Lord. I apologise for being confusing.
And that's okay.
So, just by way of introduction, further to that, if we go back to your witness statement, please, and you may have it in a separate binder, but it's also in the bundle at page 270. Just so I understand it, you studied for a diploma degree in accounting and finance in
Yeah.
Jordan. Is that correct?
Yes, that's good.
Did you become a qualified accountant?
No.
So that's sort of undergraduate accounting studies, but you didn't carry on with postgraduate studies in accounting or qualifications as an accountant?
No, I went for another part for the insurance, which is part of the finance also, as you know.
Okay. And all your career, you've worked in Dubai,
Yeah.
not in Sharjah.
No, yes, in Dubai.
And your actual job position is in the Dubai office, not in the Sharjah office.
Yeah, I'm going here and there, both.
You go, it's only a short distance.
Yeah, so because this is our company, we can go anywhere. That's it.
When you joined D12, when you joined Abnick, Horizon had already been a client of Abnick for quite a long time, hadn't it?
Yes.
And so when you first started interfacing with Horizon, it was shortly after you arrived. Is that correct?
Sorry, I didn't get you.
You first started working with Horizon in 2013. didn't you?
Okay. 2013, yes. That's correct.
And that, I think, is reflected in the evidence you gave to Justice Robert French, as referred to in his judgment. Do you agree with that?
You're talking about the statement, which I give in the...
Although we've asked to see your statements that you gave to the judge in the other case, we've never seen them. But if you look at page 883, of the bundle,
Okay.
do you recall that you gave a statement for the DIFC court on the 6th of June 2024?
Yes.
And that's referred to at paragraph 45.
Yes, that's correct.
Now, at paragraph 47, what the judge says is that the claimant, so Buhaira, started insuring the defendants against hull and war risks for specifically identified vessels in June 2013. That's not a spelling mistake. That's correct, is it?
Yeah, that's correct. Yeah.
So you had been insuring Horizon against its hull and machinery and war risks for a fleet of vessels from 2013. That was shortly, it's only a year after you joined Abnick. Can you remember who the reinsurers were in 2013 or in 2014 for the hull risks?
No, actually, I don't remember who, but for this particular hull war risk or two.
There are two policies, as I understand
Yeah.
it.
For
There's-
war risk, of course, our risk. But for the other one, there are so many people. I can't remember actually.
Well, I'm sorry. Auris first started reinsuring the war risk in 2015,
2015.
but you first started insuring Horizon's war risks in 2013.
Yes, that's correct.
So between 2013 and 2015,
Mhm.
who was the reinsurer for the war risks?
I don't know. It was not with Al Buhaira.
It was.
It wasn't with us. That policy was not insured with Al Buhaira.
You're not a reinsurance company. You're an insurance company.
It was not insured. I mean, the Horizon account was not insured with Al Buhaira that time between those periods. It was through another company.
Sorry, just let's look back at paragraph 47. What the judge says is that you said in your evidence of the 6th of June 2024 that the claimant started insuring the defendants against hull and war risks for specifically identified vessels in June 2013. So in light of that summary of your evidence from the judge, and in light of your evidence just now that you started insuring Horizon in 2013, is it or is it not the case that in 2013 Al Buhaira was insuring for war risks?
2013, yes, Al Buhaira insured that time. Okay, but later on the policy cancelled.
Later on the policy cancelled?
Yeah.
When did the
We
policy
started
cancel?
June. I don't remember exactly when, but there was some. What I can recall, and there was something about the dispute about the premium between the Horizon and the company.
I'm not talking about in 2019.
No, I'm talking about 2013.
In 2013 there'd been
Yeah.
a dispute about premium.
Yes.
And at the time, do you recall if you had gone to any reinsurance company to get reinsurance for the war risk?
That time I don't recall exactly, but what I can remember, ours was the reinsurance for Hull for war risk that time, 2013, and Hull for many other reinsurers before we cancelled the cover.
Okay, well I'm going to suggest that you're mistaken about that. It's obviously a long time ago, but between 2013 and 2015, ours were not the war risks reinsurers.
No, 13 it was ours, and before 13 also. But I was,
Sorry,
I was not.
for Horizon's fleet of vessels.
Yeah.
But all the evidence in this case is that you first approached them in 2015.
No, the first after, yes, of course. The first approach 2015 after they came back to Al Buhaira. Horizon was with other company before. Then when they approached Al Buhaira in 2015, then we approached ours. We approached for other people to.
Is this all linked to the difficulties that Mr. Al-Sari was having with his businesses and in his personal finances from 2012 onwards?
Sorry, come again? I didn't get you.
Okay, can I ask you to look in the bundle, please, at page 1686? I appreciate you might not have read this document, but it's got some helpful information which might assist. You can start by looking at page 1681. 1681. Do you have page 1681?
1681, yeah.
So this is a judgment from an English court. It's a judgment of Mr. Justice Bright between, can you see the first claimant is Commercial Bank of Dubai? Have you heard of Commercial Bank of Dubai before?
I know the bank, yes, but I don't know about this case.
Okay, and then can you see that the defendants, the first defendant is Abdallah Juma Majid Al-Sari,
I can't say his name, yes.
and the fourth defendant is Fal Oil Company, LLC.
Okay.
Have you ever heard of Fal Oil Company?
Of course I have the one, yes.
Fal Oil Company was another company like Horizon that was owned by Mr. Al-Sari, isn't that correct?
It's X-Horizon.
Sorry?
X-Horizon.
X-Horizon, what do you mean by that?
Sorry?
What do you mean by X-Horizon?
Means File Oil, it was the first name of the Horizon.
Fal Oil became Horizon, didn't it?
Yeah.
And the company was essentially owned and managed by Mr. Al-Sari.
Yes.
Was Fal Oil a client of Al Buhaira before it became Horizon?
Yes, it was.
It was. So if we look at page 1686, please. Can you see at paragraph 16, the English judge is reciting the history of legal proceedings, and he says at paragraph 16 that on the 25th of November 2012, CBD, which is Commercial Bank of Dubai, issued a claim in the Sharjah Court of First Instance in respect of amounts said to have been outstanding on a credit facility CBD had granted to FAL as borrower, in relation to which IGPL and the Al-Sari defendants acted as guarantors. Were you aware of those Sharjah Court proceedings in 2012 or 2013?
No, I don't know about anything about this.
Okay. And then can you see at paragraph 17 that on the 17th of November 2014, on the bank's application, this court, so the English court, granted an ancillary freezing order against the Al-Sari defendants and the BVI companies in respect of assets in England and Wales in aid of the Sharjah proceedings. Amongst other things, paragraphs 5 to 7 of the freezing order prohibited the Al-Sari defendants from dealing with or diminishing the value of their assets in England and Wales up to the value of 430 million dirham, specifically including any beneficial interest in the bridge properties and freehold. The Section 25 freezing order, as continued by subsequent orders, was discharged as against the BVI companies on the 19th of March 2021, but remained in force against the Al-Sari defendants until discharged on 11th of March 2022, following the grant of a worldwide freezing order in these proceedings. So isn't the position actually that what happened was that Mr. Al-Sari and Horizon were unable to pay any premium between 2013 and 2015 because all of Mr. Al-Sari's assets had been frozen?
I don't know. I did not say anything about payment of premium.
You didn't say anything, or didn't know anything about paying for premium?
No, that period. I was still in the, I told you, 2012 I joined Buhaira. Then after that, I don't know what happened. Even this case, now first time for me, I'm seeing this one.
Okay, but between 2013 and 2015, I thought you said that they were a customer, and then you stopped having them as a customer because they didn't pay the premium.
Yes, because FAL Oil is a customer not only 13, it's before also. It's not a new customer to the Buhaira. It is long back.
So Mr. Kadumi would have known all about that history, wouldn't he?
Sorry?
Mr. Kadumi, he would have known all about that history.
Maybe. I can't confirm.
And then can you see at paragraph 18, on the 29th of March 2016, so this is paragraph 18 on page 1686, the Sharjah Court of First Instance handed down its judgment on CBD's claim, ordering that the Sharjah companies and the Al-Sari defendants jointly pay Commercial Bank of Dubai 433 million dirham plus interest and costs. Were you aware of that judgment that the Sharjah Court of First Instance issued against Mr. Al-Sari
No,
for 433 million?
No, I'm not.
And then you see at paragraph 19 that on the 27th of February 2017 an appeal against the Sharjah judgment was dismissed. And at paragraph 20, Mr. Al-Sari and his son Majid Al-Sari filed a petition for review of that judgment on the 23rd of February 2020. The appeal was dismissed by the Sharjah Appeal Court on the 26th of April 2021. Were you aware of those developments in 2017, 2020 and 2021?
No, I don't know about this.
It was big news, though, wasn't it, in Sharjah?
Sorry?
It was big news in Sharjah, wasn't it?
No, but this is not related to my work. So I'm
Not related to your work. Now, just going back then to your witness statement, sort of put H to one side. If we go back to your witness statement,
Yeah.
at page, it may be separate, but it also starts at page 270. Can I just ask you to look at paragraph 1.2, please, which is at page 271. You've been asked, you say, by ABNIC to provide a witness statement on certain matters.
Yeah.
And then in the third line, you say, more specifically, I've been asked to provide my comments in respect of an assertion made by ARIS in its amendment statement of defence that Mr. Abdullah Juma Al-Sari knew or ought to have known about certain factual matters that were not disclosed to me in the course of the renewal of the Marine Hull War Policy. Do you remember being asked to deal with that matter?
Yes.
And then can I ask you to look, please, at paragraph 3.2, at page 273. Can you see that what you said there is you say, although I can say nothing about whether the underlying insured was a shareholder of ABNIC or of Mr. Al-Sari's role as a member of the Board of Directors of ABNIC, I was the underwriter responsible for the renewal of the war policy. And so I'm well placed to give evidence about what was made known to me during the renewal of the war policy. Do you remember saying that?
Sorry?
Do you remember writing that or signing that statement?
Yes, I can write it.
Okay, but the true position is that the underwriter actually responsible for issuing and renewing the war policy was Mr. Kadumi.
No, it was my Mr. Kadum, as we explained earlier. The underwriting by technical department, which is done by me, and the authority was Mr. Kadumi to sign the policy. It's going for him.
Okay.
We are recommending to him the terms and conditions.
If Mr. Kadumi was here, Mr. Kadumi would be in a position to answer my questions with knowledge of Mr. Al-Sari's role as a member of the board of directors, wouldn't he?
Well, I'm not sure what this witness can give evidence as to what might or might not be the case on a hypothetical basis. This witness is here to give evidence about things he knows about, not about matters that are conjecture.
I think he can give evidence of his knowledge of the interactions between individuals that he's observed.
Yes.
Shall I repeat the question or reframe it?
I think you can reframe it in terms of, well, I don't want to dictate, but I think the area for examination is what he knew from within the office and the interactions between individuals, if I can put it that way, as neutrally as possible.
Okay, you were based in the Dubai office, you are based in the Dubai office, but you travel to Sharjah frequently for work. And you know of Mr. Kadumi's position as general manager and Mr. Al-Sari's position on the board of directors.
Okay.
Mr. Al-Sari was on the board of directors until April 2022, wasn't he?
Yes, correct.
And he'd been on the board of directors from 1982, isn't that correct?
1982, I don't know.
You don't know. But for as long as you were at the company between 2012 and 2022, you were aware that Mr. Kadumi had interactions with Mr. Al-Sari on the board.
Of course, Mr. Kadumi, I have no comment on this one, but I can explain. Mr. Kadumi, of course, there are the board member meetings regularly, and which involve Mr. Kadumi and board members together. Of course, they know each other. But I cannot comment anything else about this one.
Okay. Now, I'll come on to a bit more detail in a second, but Abneg, just so I've got this correct in everyone's mind, Al-Buhaira was incorporated in 1978. Do you know that?
Yeah.
And in 2005, it became a publicly listed company, whose shares are listed on the Abu Dhabi Stock Exchange.
Yes, that's correct.
So it has public shareholders who buy its shares through the stock exchange.
Okay.
Is that correct?
Of course. You are talking about the city?
I'm sorry.
You're talking about city or about the company itself? A shareholder, you're talking about the city?
No, I'm talking about, so Al-Buhaira,
Al-Buhaira, yes, it became, yes, 2005.
2005, it became publicly listed
Yes.
on the Abu Dhabi Stock Exchange.
You can buy shares, yes, that's correct.
So its shares are not listed in Sharjah, it's not listed in Dubai, its shares are listed on the Abu Dhabi Stock Exchange,
No, Abu Dhabi is part of the UAE.
part of the UAE. And because it's publicly listed, it has hundreds of shareholders who buy and sell its shares.
I don't know about this one. You can buy sell share, of course. But it's public for everybody, so you can buy share. Anyone can buy share on that.
Okay. Now, do you know that for the past 3 years, so the years ending 31 December 2022, the year ending 31 December 2023, and the year ending 31 December 2024, Al-Buhaira has made operating losses for each of those 3 years?
Operating losses?
Yes.
No, there is. Of course, we know, as according to the statement of fact, of course, yes.
So in 2022, it made a net loss of 35 million dirham.
Yeah.
Actually 34.494.
Okay.
In 2023, it made a net loss of 133 million dirham.
Okay.
and in 2024 it made a net loss of 36.9 million dirham.
Okay.
Have you seen the audited financial statements dated the 25th of March 2025 for the year ended 31 December 2024?
No, I didn't see it.
Do you mind if I show you them and also circulate copies for the judge and Mr. Craig, please?
Maybe not 15.
Judge, are you okay if I hand these up to the witness?
Yes.
Okay. So that's for the witness, and this is for the judge, please.
I take it, Mr. Craig, you don't have any objection to this?
I will no, but what I will object to is any questions that don't ask this witness about things he actually knows. He's already said he's not seen this document, and so it can only be used for things which points to potential areas of knowledge of this witness. If he's going to be cross-examined on this financial statement.
Sorry, I think Mr. Craig's microphone is off. I can't hear.
If you're going to be cross-examined on these financial statements as financial statements, then I will object to that.
Is it on or off? I think the microphone might be off. You can hold it to your face, but I think it might be switched off. I can't quite see
Just tap it on top.
from my...
A bit closer.
Is it on
Is
a
it green?
steady green?
It is now on the green. There we go.
Thank you.
Okay, so we just want to repeat for the record what you said.
Yes, I said I don't have an objection to this document going in, as I understand it is a matter of public record. If it's not, then it shouldn't be being adduced. But what I object to is any questions being directed to this witness which don't pertain to his actual knowledge.
Okay, thank you.
Just to explain, Mr. Shalab, I've given you 4 documents which are attached with a small string,
Okay.
and there are some post-it notes, I think, which show you where the beginning of each document starts. These are all documents that are publicly available either through Al Buhaira's own website or through the Abu Dhabi Stock Exchange website, because it's a public company. But the first document, which you see there, has the page numbers in the bottom right-hand corner, and it starts at page 1. Can you see that? And
This one?
the document is headed Al Buhaira National Insurance Company,
Okay.
and it's called Integrated Report for the Financial Year ended 31 December 2024.
Yeah, okay.
You have that document?
Yeah, I see.
And can you see the page number at the bottom right is
Yeah.
1?
Yeah.
If you flip forwards in the bundle to just before the next post-it note, you'll see that the last page of that document also has a page number.
What is that?
It's a blue photograph, I think, of Al Buhaira's headquarters with page 202 on the blue background. Do you have that complete document then?
Yes.
Okay. So if we just look at the page 2, please. Can you see at page 2, there's a contents section which says, first of all, Board of Directors report, page number 3.
Okay.
2 consolidated financial statements, page number 4. 3 corporate governance report 2024, and 4 ABNIC sustainability report 2024.
Okay.
The first of those documents, which, as Mr. Craig has pointed out, you might not have seen yourself, but can you just look at it, please, at page 3? Can you see that's the Board of Directors report for the year ended 31 December 2024? And it's addressed to the Disclosures and Compliance section, Market Operations Surveillance Department, Abu Dhabi Securities Exchange. Can you see that? It's
Yeah, I
dated
can see that.
25th of March.
Yes.
And can you see that it says that Al Buhaira National Insurance Company has relatively improved its technical results in spite of recurrent natural mishappenings? It's rewarding to note the company's management has decided to increase the outstanding motor claims reserve as well as IBNR, which reflect a conservative attitude in view of the increase of the average cost of claims. And just on that paragraph, were you aware of that management decision, which is to increase motor claims reserves as well as IBNR?
No, I was not aware.
We then move to the next paragraph. The company reported insurance losses of 51 million dirham for the year ended 31 December 2024, compared to 149 million on December 23. And that paragraph, I think, is talking about insurance losses only. But then the next sentence, the company's net losses amounted to 37 million dirham in 2024, compared to 132.8 million net loss in 2023. And those are some of the numbers I just put to you a bit earlier. You were aware of those numbers, weren't you?
Through the public only.
Through the public only. Okay, now, if we then turn over the page, please, to page 4, you'll see that these are now the consolidated financial statements for the year ended 31 December 2024 for Al Buhaira National Insurance Company, PSC. In the course of your work, were you asked any questions by management or auditors about the information that should go into these documents?
No.
But you are the head of marine underwriting and claims.
Yes.
Do you have any responsibility for setting reserves?
No.
How is that possible if you're the head of claims?
Reserve, you are talking about company reserve or department reserve?
Well, you've told us you're the head of marine underwriting and the head of marine claims,
Yes.
is that right? So when somebody makes a claim for a vessel, an insured,
Yeah.
says their vessel has sunk
Okay.
or it's been stolen, are you in charge of dealing with the claims?
Yes, correct.
And when you deal with a claim, do you have a system in the company where you have to fix a reserve for the company's accounting purposes? Yes?
Yes, correct.
So in that capacity, aren't you in charge of fixing the reserves for the marine file? Yes?
Marine claims, you are talking.
Marine claims.
Yes.
And that information, the reserves information, you provide to the company's accountants.
Yeah.
Yes?
Yes, we are the one who providing the reserve for the company in terms of marine department.
And the company's accountants
Yeah.
will provide that information to the company's management. Is that correct?
Yes.
So Mr. Kadumi, for example,
Yes, correct.
and the board of directors. And they, in turn, will provide that information to the auditors of the company. Is that correct?
Yes. I don't know exactly what is the procedure, but our technical part is just to provide the financing. Now, whatever related after that one is not our responsibility.
Okay. And then to state the obvious, the auditors then provide their audit report, which is then disclosed to the shareholders of the public company,
Yeah.
as well as to the Abu Dhabi Stock
Security,
Exchange,
yes.
and also to the Central Bank of the United Arab Emirates. Isn't that correct?
Yeah.
Yes?
Yes, correct.
So one of the critically important functions that you perform is fixing the reserves accurately,
Correct.
because it is of essential importance to an insurance company to know precisely what its assets and liabilities are at any given moment, and certainly when reporting to the general public and the regulator and the bank.
Yeah.
Yes.
Yes, that's correct.
So you would take care, wouldn't you, to reserve correctly and accurately?
Of course. Yes.
Now, can I just ask you to look, please, at page 7, which is the independent auditor's report of Grant Thornton Audit and Accounting Limited. Did you know that Grant Thornton are the independent auditors for Al Buhaira?
Yes, I know.
Do you ever receive questions from Grant Thornton to assist them with their audit?
No. Never.
No? You never receive questions. Do you ever receive questions from Mr. Kadumi to help him answer the audit questions?
I don't know. You mean the auditor address to the
Well, does Mr. Kadumi ever come to you during the course of the year to say, I've received some questions from the auditors, can you help me answer them?
No.
Do you have any questions from
If
the
there is,
account?
of course, he will come. If there is any comments, of course, yes, he will come.
Okay. So can you see that at page 7, under the words emphasis of matter towards the bottom, Grant Thornton has said, we draw attention to note 28, the consolidated financial statements. The group has a deficit in the solvency margin requirements and minimum guarantee fund requirements as stipulated by the Central Bank of the UAE, by the amounts of 186 million dirham and 30 million dirham respectively. Were you aware of those two facts?
No, I haven't done. I don't know about this.
Don't think about that. Okay. Now, can I ask you also on that page, just to see under the words basis, well, just above basis for opinion, the second paragraph, the auditors say, in our opinion, the accompanying consolidated financial statements present fairly in all material respects the consolidated financial position of the group as at 31 December 2024, and their consolidated financial performance and their consolidated cash flows for the year then ended in accordance with IFRS accounting standards as issued by the International Accounting Standards Board, ISAB. Are you familiar with IFRS accounting standards?
I'm familiar, but not that much. I think the accounts team who's the right person who can answer you for this.
So what about the publications of International Accounting Standards Board such as IAS 37? Do you know about IAS 37, dealing with provisions, contingent liabilities and contingent assets?
That is financial matters which I cannot answer you on this. I don't know.
So even though you studied accounting,
Yeah, all this relative.
that all came later?
So,
Okay. Can I ask you to look, please, at page 8. Can you see at the left-hand column in this table under the heading Key Audit Matters, the auditors have said, as at 31 December 2024, the group's reinsurance contract assets, insurance contract liabilities, and reinsurance contract liabilities are valued at, and they give 3 figures, referring to note 9. And they say valuation of reinsurance contract assets and liabilities involves significant judgments and estimates, particularly with respect to the eligibility of measurement models and estimation of the present value of future cash flows. These cash flows primarily include determination of expected premium receipts, expected ultimate cost of claims, and allocation of insurance acquisition cash flows, which are within the contract boundaries. The calculation for these liabilities includes significant estimation involving actuarial experts in order to ensure appropriateness of discount rates, methodology, assumptions, and data used to determine the estimated present value of future cash flows. As a result of the above factors, we consider valuation of reinsurance contract assets and liabilities as a key audit matter. Now, would you agree with those statements? Is valuation of reinsurance contract assets a key audit matter?
With respect, my lord, he said he'd not an accountant. How can he possibly know what is or is not a matter for an auditor?
I think that's a fair objection.
I mean, if my learned friend wants to make submissions about a stock, absolutely entitled to, but not with this witness, save the things which this witness knows about.
So sorry, I'm so sorry, the microphone is off. The objections are not going on the record.
Do you put your microphone back on and repeat the objection?
My lord, the point is this witness is not an accountant, is not an auditor, and cannot possibly, in those circumstances, give evidence about what are not audit standards. All he can be asked about is things he actually knows about.
Like any good judge in the movies, objection. Sustained, yes.
Can I ask you to look, please, at page 13 of the bundle that you've got there? This, as I understand it, is the consolidated statement of financial position as of 31 December 2024. Do you see at the bottom that this has been signed by Sheikh Faisal bin Khalid bin Sultan Al Kazimi, the chairman, and by Mr. Kadumi in his capacity as CEO? Do you see that?
I can see it.
And in summarising the position, under the word assets at the top, you have at the 5th line a line which says reinsurance contract assets. Do you see that?
Yeah.
And it provides the figure for both 2024 and 2023 in dirham. And then if you look, please, under the words equity and liabilities, can you see under liabilities, the 5th line down, insurance contract liabilities with the figures there, and reinsurance contract liabilities with the figures there, and a reference to note 9. Do you see that?
I can see figure, yeah.
Okay. Now, if we then look over the page, we see the consolidated statement of profit and loss. And those are the figures, I think, if you look at the bottom that we were alluding to earlier about the 2024 and 2023 losses for the year after tax. Do you see those?
Okay, you can see.
Can we look, please, at notes 9? And to pick this up, you need to turn, please, to page 43. Can you see at the top of page 43, which is 38 of the document, note 9, insurance or reinsurance contracts, the breakdown of groups of insurance or reinsurance contracts issued, reinsurance contracts held, that are in an asset position and those in a liability position are set out in the table below. Can you see that then the notes break down into the different classes of business or different departments?
Okay, I can see, yes.
Motor, marine, FGA, medical and life. Your department is involved in the marine bit of this.
Okay.
Note 9.2. Do you agree with that?
Yes, I can see.
So would you have direct knowledge of the insurance contract liability figure that is 82 million dirham?
No, I don't have.
You don't know what the overall liabilities of the marine insurance businesses are?
This one, I said, I am not the finance who can answer these questions because this is not on consistence of the claim of the reserve. This consists of many things. So this, I think, the right person who can answer this question is the finance team.
The finance team?
Yeah.
So as head of marine claims, you wouldn't be expected to know what the figure should be for the head of liabilities?
I can, because there's actuarial figures, not underwriting figures. With the actuary, there is reserve. If I put, like, for example, 10 million in reserve, maybe the actuary will put 20 million. So I cannot give you the exact figure from it. I cannot comment about these figures.
Okay, then if we look down at note 9.7, so under reinsurance contracts held, can you see for 9.7, for liabilities with respect to reinsurance contracts held, there is a dash.
Yes.
So is that your understanding, that you as a company owe zero money as at 31 December 2024 to any reinsurers with respect to marine business?
No, I cannot comment about this one also.
Okay. Now, 9.2, that note, we saw the reference there. Can I ask you to look, please, at page 45? Can you see, please, at the top, 9.2 marine. You then have the year 2024 and various columns. The first set of columns are liabilities for remaining coverage, and the second column relates to liabilities for incurred claims. Now, if I understand that correctly, liabilities for remaining coverage is talking about existing policies which may actuarially require some calculation as to the potential liability. Whereas the second column, liabilities for incurred claims, relates to claims which have already been presented to the company. Is that correct?
Let me just read it. Yes.
So if you look at the column to the right, so the third column actually, estimates of the present value of future cash flows under liabilities for incurred claims, you'll see the text on the left says insurance contract liabilities as of 1 January. The total figure there is 25 million dirham.
Okay, I can see the number.
And what is clear is that that figure does not include a figure for $70 million for the beta, does it?
Yes, it was not included.
And the position is that Al Buhaira has set a zero reserve for the beta claim.
Only for the peace reserve. As you know, we won the case and there was no reserve for the beta. The claim was rejected. That's why we did not get any reserve.
So because the claim was rejected, you've set a zero reserve.
Yeah.
And that's the position from 2021 to date, isn't it?
Yes. Only just the reserve for the expenses only.
So if we look at the lines a bit further down, are you saying that you reserved under the words incurred claims and other expenses? Is that where the legal fees are reserved for?
Which page, which line is that?
Well, so page 45, the insurance contract liabilities is the first line, and that's clear that the beta claim is not included there. Are you including the costs liabilities
Yes,
in the 25 million dirham figure? Or are you including them under insurance service expenses, which is the line, 2 lines down, which is 37 million dirham?
I don't know about this one. I think, as I told you, the finance team can answer this question.
Okay.
It's not my part to about these figures.
Now, do you know what the figure was for reserving for the legal expenses?
Currently or previously?
Well, it could be as of today, or at the 31 December 2024.
Whatever an expenses incurred, we are already there is reserve for that one.
You've reserved for expenses incurred.
Expenses and whatever any reserve related to this beta, it is already there is reserve for that one. Yes.
But absolutely clear, nothing for the $70 million value of the ship.
No.
And that is, it's not something which has changed because of the judgment of Robert French in September of 2024. It's the position you've taken on advice from 2021, isn't it?
Yes, that's correct.
And you can see that if you look further down the page at 2023, so halfway down, just under 2023, insurance contract liabilities as at 1 January. If you go to the middle column, the estimates as at the end of December 2023 for reserves were 32 million dirham.
Yes.
So way before the judgment, zero reserve for the ship.
Yeah, because of course that time the claim was not admitted. That's why.
And that reflects the fact, doesn't it? It reflects the basic fact that Al Buhaira considers there to be no risk of the beta claim ever being successful.
Yeah.
Yes. If, in fact, there was any perception by you, or by Mr. Kadumi, or by the Board of Directors, or by the auditors, if there was any perception of a contingent liability with respect to the beta claim, it would have to be reserved for and accounted for in these audited financial statements, wouldn't it?
Yes, it will appear there.
So it follows, doesn't it, that you, as well as Mr. Kadumi, as well as the Board of Directors, as well as the auditors, all consider there is zero risk of that claim ever being made good.
It's not about zero risk. It's just about like claims from the beginning. If I can allow me to explain this one, it was at that time. It was the claim like it was not admitted by the Buhaira. That's why we did not take reserve. Only but we keep the claim open for in case if there is any legal fees, any things which the client, made legal proceeding against the Buhaira. So we keep the claim open and for like fees and money exception coming to keep some reserve for that one. Of course, legal fees has to have some reserve.
Now it's notable, isn't it, that in your witness statement, you don't give any evidence in the statement about the underlying claim at all.
Which this witness or the previous?
If we go back to your witness statement at page 270 of the bundle,
Let me go to 270.
so I think you had it separately, but it's also at 270 of the bundle through to page 276. You didn't provide any evidence at all about the status of the underlying claims or the DIFC court judgment, or the fact that there's been no reserve and that there is therefore no material risk of any claim being successful?
No, my statement only about the things which is appear here now in the court, which I need to give a statement about these 2 points. Not anything else.
Do you have any involvement in Al Buhaira's position before the Sharjah court? Are you involved in giving instructions to the lawyers, or is that somebody else at Al Buhaira who does that?
Instruction in terms of like appointing the lawyer, or what?
Well, who tells the lawyers what Al Buhaira wants to do next?
Of course, the technical department, yes. We and including our lawyer also, the company lawyer.
The internal company lawyer
Yeah, internal, yes.
from the legal department.
Yeah, we are giving the instruction, of course,
Okay.
because the claim is against the marine department, so we are giving instruction.
Now, you know that you won the case in September 2024, don't you?
Yes, of course,
And that was a final and binding judgment of the DIFC court.
correct.
Do you know why it wasn't until yesterday, apparently, that your company decided to take steps to shut down the Sharjah court proceedings?
Of course, because the Sharjah court proceeding, this is, I think that my lawyer he can answer this question, but Sharjah proceeding they decline it and they give the favor to the FC court that time.
Okay, so the stay of proceedings in Sharjah was on the basis the Sharjah court would defer to the DIFC court, is that correct? And so the result in reality is that when you won in the DIFC, you've also won in Sharjah.
Not yet, not.
But isn't the true position that what you could and should and reasonably could have done, is go to the Sharjah court as soon as you had the DIFC court judgment? But the only reason you didn't is to try and keep this claim alive against Aris,
I can't answer this.
or to keep the file open, as you say.
Of course, we spend a lot of money for this one. Of course, this is we want the case to cover our expenses. That is surely keep the claim open still.
Exactly, it's contrived. You're keeping the claim alive, not because the claim has any value ascribed to it, but simply to keep alive the claim for costs.
Yes, because we won the case. There is no, as per the just 24 September, we won the case that line, and there is no, Atlantic has no claim against Buhaira. But of course, the claim still running because to recover the fees.
And in fact, not only have you won the case, you've got cost orders against Horizon in your favour. So you can recover the fees from Horizon, can't you?
Of course, yes.
Yes.
But from our insurance also, not only Horizon.
Sorry.
Because when expenses spent regarding this particular case, it is from the reinsurance, not from Horizon.
Hang on. As I understand it, what you are concerned about are the costs of defending Horizon's claim. And those costs, the court has ordered Horizon to pay to Al Buhaira. Isn't that correct?
Yeah.
And so those costs you can recover from Horizon.
I'm not sure on this one. If we can recover from Horizon or not.
Do you have any knowledge in relation to attempts to recover the costs of the legal proceedings in this court from Horizon?
No, sir, I don't.
Thank you.
Now, if we go back to the accounting documents, the financial statements I've just been showing you, we had seen, I think, at page page 45 of the bundle that you're just looking at. We've just looked at note 9.2. Can I ask you now to look at note 9.7, please, which is at page 51. Can you see that this is now still notes for the insurance and reinsurance contracts of Al Buhaira's accounts section? And on 9.7, marine, this is now talking about the roll forward of net asset or liability for insurance contracts held, showing the assets for remaining coverage and the amounts recoverable on incurred claims continued. If you look, please, at the column to the right, so the second set of columns under the heading Amounts Recoverable on Incurred Claims, Estimates of the Present Value of Future Cash Flows, AED, there's a figure of 26 million dirham. Now that represents, doesn't it, reinsurance recoveries that Al Buhaira expects to make against its reinsurers across its marine book of business. You see on the left, it says 2024. The first line is reinsurance contract assets as at 1 January. And in terms of the second column, amounts recoverable on incurred claims, estimates the present value of future cash flows, 26,115,000 dirham. And there's a risk adjustment of 1.6 million dirham.
Okay.
And then you have, the third line is net reinsurance contract assets of 30 million dirham.
Okay.
Doesn't that represent the total amount that the marine department and the accountants and the auditors think that they are owed by reinsurers across the book of business at this point in time?
As I said, I cannot comment on these figures because this is set by the accounts and finance team.
Okay, and then if we look down a few lines beneath that, amounts recoverable from reinsurers for incurred claims, amounts recoverable for incurred claims and other expenses, and there's a figure there of 15 million dirham.
Yeah.
Now, is that 15 million dirham figure the figure that you have assigned to the value of all of the legal costs relating to the beta claim?
No, this is not only the beta. This is all in general. It's not talking about beta here.
It's not talking about
Not only specific claim. This is only in general.
the entire marine department's legal fees.
Yeah. Not fees. This is the reserve limit. What is from the reinsurance? Their share. The insurance share of the expenses or claims, whatever.
Does it include the 10 million dirham in costs that we have received notice of in correspondence?
That I don't know. You need to check with the finance team. I have no comments on this.
You don't know about that. I mean, it's your department. Your department is
No,
in
my
charge.
department I told you, but this is the actuary report, not my report.
Okay.
I have our own report. Okay, we know, but this is there is actuary. They have more reserve. This reserve. We don't know.
But can we roll this back slightly? You will have attributed a figure to the recovery of costs in relation to beta.
Correct.
And then you will have communicated that to directly to the auditors or to the finance team?
To the finance.
Okay, and then the finance team then speak to the auditors.
Correct.
Yeah. So this figure comes from the finance team, but the finance team must have input from you.
Correct.
Okay.
That is the
So, can you remember, as at 2024, 31 December, can you remember what figures you provided the finance team with respect to the legal expenses for the litigation relating to the beta?
Beta alone, because no. See, the report is not specifying claim by claim. It is just overall. You are talking like as of 31st December 2024, the whole figure outstanding, like reserve, it will be sent to the accounts. They will not say this for what and this for what. But of course, beta will be there. And anything reserved for beta will be included there in that figure.
Now, can I ask you to look at can we look at the next page, please? So page 52. Can you see that this is now a similar set of entries, but for the 2023 year? So it's note 9.7 marine continued, and then 2023.
Yeah.
Can you see that for the equivalent figure in the third column, 4 lines down,
37 million.
there's a figure of, for amounts recoverable for incurred claims and other expenses, the figure is 5,168,097 dirham.
Okay.
Can you explain why there's a difference over the course of the year between the 5 million dirham figure and the $50 million figure?
I don't know about this one.
You don't know about that. Now, if we go please to page.
I would have thought that's quite obvious. The trial in this court took place in 24.
Of course.
Yes.
But this witness tells me he doesn't know anything about it.
Yes.
There will be inferences to be drawn from this evidence, my lord.
Okay.
Can I ask you now quickly to look, please, at page 70, 70. Can you see at note 26, contingencies and commitments, under the word contingencies, legal proceedings, the group is involved in various legal proceedings and claims arising in the ordinary course of business. While the outcome of these matters cannot be predicted with certainty, management does not believe these matters will have a material adverse effect on the group's consolidated financial statements if settled unfavourably. Can you see that?
I can read it, yes, I can see.
And do you know what, for the Al-Buhaira's purposes, a material change, or how much does the sum have to be to constitute a material change to the finances?
That, I think, is a
I don't know.
very technical question.
That's fine. You don't have to answer that. Can I ask you look, please, at page 75. Can you see at note 28, halfway down the page, under the figures in the middle? Then this is the note that the auditors had emphasised. As of 31 December 2024, the group has a deficit in the solvency margin requirements and minimum guarantee fund requirements, as stipulated by the Central Bank of the UAE, by an amount of 186 million dirham and 30 million dirham respectively. The group's ability to comply with solvency requirements depends on implementing an effective business plan. Can you see that?
Yes, I can see this.
Are there any concerns so far as you're aware of relating to Al-Buhaira's solvency?
I cannot comment on this one.
You can't comment on it. Now,
It's not relevant to that.
isn't the position here that because of Al-Buhaira's delicate financial position, you have on the one hand ascribed zero value to the beta claim correctly, but you have then separately ascribed a $50 million dirham as a current asset to the costs, when in fact the costs are no more than a contingent asset.
don't understand. Can you please repeat the question because the question is not clear?
Well, not again, with respect. This is not a question for this witness.
It's a comment, and it can be made in due course, I think.
If it turned out that your department was not going to recover 15 million dirham in legal costs, you would be in some difficulty, wouldn't you?
No. Because there is a reserve for that one.
That's a reserve. It's reserved not as a liability, but as an asset.
I cannot comment on this one. I don't know exactly what you are trying to reach, but
Okay. So we've seen how you've, in your accounts, your company's accounts,
okay.
$15 million dirham in legal fees is being accounted for as a current asset.
Okay. What is the question?
So if in reality it's not a current asset,
Lord, I'm sorry. This is a technical question about accountancy, which this witness cannot possibly answer. It's. Anyway, I'm making my point.
I think that's right. I mean, while he started accountancy 25 years ago, I think we are straying into quite technical areas.
let me put it another way. Were you sitting in court yesterday morning, by any chance?
Okay.
Were you in court yesterday
Yeah,
morning?
I was there, yes.
Okay. Did you hear your lawyer, Al-Buhaira's lawyer, explain to the judge that Al-Buhaira is not seeking payment of any money?
To Horizon.
In these proceedings, Al-Buhaira is suing Aris. And what Mr. Craig explained to the judge is that Al-Buhaira are not seeking payment of money from Aris.
I did not hear that one yesterday.
You didn't hear that?
I didn't hear so.
So it's the case that we had a debate with the judge about whether or not they were claiming 6 million or 10 million dirham in these proceedings. You didn't hear any of that?
No. Maybe I think he can answer this question.
Somebody else can answer it. Okay, but the position appears to be that all that is being sought is a declaration without any actual claim for a debt or damages against Aris.
I think we're also now getting into a technical legal area from the accounting. The difference between a declaration of indebtedness and actually claiming the debt is an esoteric one.
The reason I'm going to suggest to you, because you're the head of marine underwriting and head of claims,
Okay.
and I don't have Mr. Kadumi to ask this question of, the reason I'm going to suggest to you that all that Al-Buhaira is seeking are a declaration is because they do not want to create a situation whereby it turns out that these accounting entries are false.
I cannot, no, it's not false, but I cannot comment on that one.
Because as soon as they crystallize any analysis or assessment of whether the $15 million figure is reasonable or verifiable, it will turn out that these are not correct financial accounts and that the solvency deficit and lack of profitability of the company is even worse than is currently being reported.
I have no idea about this.
Okay. Can I ask you, please, to look in the trial bundle now, please?
Are we moving on to another topic? Because I do want to give the court reporter a break.
That's fine, yes.
Well, it's let's say we'll resume at 20 to 12.
Yes.
All rise.
Thank you. Can I ask you to please look now at page 110 of the trial bundle, please? So 110 of the trial bundle is a document called the first witness statement of Leonard Sudegar.
Okay.
Have you seen this before? Do you know?
Yes, yes, this one.
Can I ask you to look then, please, at page 119 of the trial bundle? Can I ask you to read paragraph 22, subparagraph 2, in the middle of that page with me? It says, Clyde & Co. has been issuing invoices to the claimant since April 2021, and the total amount invoiced by this firm, plus disbursements and VAT, stands at 6 million dirham. Therefore, the costs and expenses incurred by the claimant in seeking to avoid and or limit its liability of the underlying policy to date stands at least at 6.1 million dirham. The claimant will continue to incur costs and expenses in this respect until the direct proceedings, brackets and the Sharjah proceedings, are finally concluded. This is not an immaterial sum of money to the claimant. And I'm instructed by the claimant the defendant's failure to indemnify in respect of these costs is having an adverse impact on the claimant's solvency. Now, can you recall whether you were the person at Al Buhaira who instructed Mr. Sudagar to say that?
Instructed who? Can you repeat?
This is evidence given by Mr. Sudagar of
Okay.
Clyde & Co. And you see who says that I am instructed by the claimant that the defendant's failure to indemnify in respect of these costs is having an adverse impact on the claimant's solvency. Can you remember whether it was you who told Mr. Sudagar to say that?
No, I don't remember.
Do you think it was Mr. Kadumi who would have told them?
Also, I don't know. Whether
You don't
it's
know. Okay. Now, you'll. Can I ask you to look, please, at page 859 of the bundle? Can you see it, 859 of the bundle through to 861, a table? Have you seen that document before?
Yes, I saw this.
Did you have input into its preparation?
No,
You didn't insert the figures or do the arithmetic?
this is in line with our figures. Same.
But who prepared this information? Was it you or somebody else in your team?
No, this is came by Clyde.
Clyde & Co. prepared this document. Okay. Now, can I ask you to look, please, at pages 193 to 194? Oh, sorry, if we start, please, at page 189. 189. Have you seen this document before at page 189? It's the claimant's response to the defendant's request for further information, dated 3rd September 2024.
Yes, I read it. I believe it.
And if you look at page 195, can you see Mr. Kadumi's signature at page 195?
Yes, I can see.
Would you have discussed this document yourself with Mr. Kadumi before he signed it?
Yes, we discussed together.
So you read it carefully yourself?
We read it, yes, jointly.
Okay, can I ask you to page 193, please? Can you see the request number 5? The question was of paragraph 24 of the amended particulars. But the text in that document was an assertion that the claimant is entitled to and claims all costs and expenses incurred by in claims brought by or against the insured under the underlying policy. Now, my understanding is the reference to the underlying policy was a reference to the marine war risks policy. Is that correct?
Yeah.
Not the hull policy.
Yes, that's correct.
So the question then was, please state with full particularity the monetary value of all such costs and expenses incurred to date and that are estimated to be incurred between today's date and the date of trial, and please provide full and proper particulars and detailed calculations with respect to all such sums. Now, can you see that the answer in red, the response given on behalf of Al Buhaira, was that the total claim to date is AED 8,500,000 odd, particulars of which are set out below, supporting invoice being provided in the claimant's standard disclosure. And can you see this table that's been prepared? If you look over the page at 194, you reach a total of 8.23 million dirham. And then there's another table of some additional invoices or documents which create creates another subtotal of 344,000. Now, did you have involvement in compiling that table?
Actually, yes, of course, reconciliation.
So you tried to reconcile all of this.
Yes, and according to that, whatever we paid, because this all invoices came by the lawyers involved in this case.
And are you 100% sure that all of these entries, all these invoices, relate only to legal costs relating to the marine war risk policy?
Yeah, for that beta case, yes.
Sorry?
For beta case, yeah.
Well, specifically, do they relate 100% to the war risks policy?
War risk, yes.
Now, can you see at page 194, the second table, number 91, the description is Al Tamimi & Co. and the date is 31 of August 2021 and the amount is 31,000 dirham. Can I ask you to look, please, at page 929? Can you see at page 929 an invoice from Al Tamimi to Issam Medawi, Ibn Abnik? Do you know who Mr. Medawi is?
Yes, I know.
Who is he?
He's our head of general insurance.
Head of General Insurance.
FGA, Fire and General Insurance.
Fire and General Insurance. He's not involved in marine war risks.
Maybe this wrongly addressed him.
The address is wrong, is it?
Maybe.
And then can you see the subject line? Advise the client in a hull claim filed by Horizon Energy under the insurance policy.
Yes.
So this invoice doesn't relate to the marine war risks, does it?
No, it is related to marine. But wrongly addressed to the wrong person.
It doesn't relate to the war risks policy,
No,
but
it's
the
related
hull
to-
policy.
I don't recall whether hull or war, but this addressed to marine. But the name is addressed, there is wrong name, I think, they addressed to Mr. Islam.
And the reason is because initially the claimant, Horizon, was in fact presenting its claim under the hull policy.
Can you repeat please again?
The reason Al Tamimi are referring to the subject line as being advising the client in a hull claim filed by Horizon Energy under the insurance policy, the reason they're referring to that is because originally Horizon presented a claim under the hull policy.
No, they present for both, not only under one. For both processes.
Well, even if they present under both, it can't be right, can it, that this invoice relates solely to the costs of the war risks policy?
See, it is related to the beta case claim. Regardless whether it is for hull or for war, it is just for that case, exactly. But I can't recall because it's very old, in 2021, I don't recall exactly. But we have details of that invoice, by the way.
I don't mean to cut you short, and I recognise that you may make submissions on credibility and so on in relation to this, and this is an example, but we don't need to go through, do we, the individual numbers, because that's not for this trial in any event. So
We're not going to go through invoices. This is really one example, but there will be many to make about it. Can I just spend 2 more moments on this point? And then move
yes,
to my
but I
next
mean,
one?
I understand where you're going with it. Well, yes, but you know, we don't need to spend a huge amount of time on it.
Can I ask you to look, please, at page 944? At 944, you'll see an Al Buhaira tax credit note addressed to Al Tamimi and Company. Do you see that?
Yeah.
And can you see that the office and the class and the policy type are referred to as marine hull and liability and marine hull in the top left.
I can see that, yes.
And can you see that the policy number there is SF?
Yes,
So 18/SF.
I can see, yeah.
That's the policy reference to the hull policy, isn't it?
114, it is the war policy, it's not one.
But the war policy is SH, 18SH.
SH. I don't have to check the documents. Just document in that.
Okay. If we look, please, at I'm sorry, you might be right on this. Let me just double check. If you look at, please, page 500, let's just check this.
War policy.
Hull is SH.
So UL is SH, and the
War is SH.
war is SF.
SH.
Sorry. Hull is SF. You see that at 504. Is that correct?
Go to the one. Yes, hull is SF.
So Hull at page 504 is SF. Is that correct?
But 500 is SH.
SH.
Precisely. So if you go back to page 944, can you see the reference there to SF? And with the SF reference in mind, and you go back to 504, isn't it the case that the SF reference is a reference to the hull and machinery policy?
Yeah, that's hull and machinery policy is SF, yes.
So
113 number.
well, you can see from the tax credit note that both by reference to class, marine hull and liability, and the policy type, marine hull, and the policy number ending with SF, and the claim number, CSH hull, all of that information that goes into Al Buhaira's own tax credit note to Al Tamimi is reflecting the fact that the payment is being made with respect to the hull policy.
No, it is for war policies. SF, I told you as explained in the beginning, this is only just for our like an individual, like just for collecting premium. Has nothing to do with the policy number itself. The policy number is the same, 114.
Well, I'm going to suggest this is obviously just one example of many, but if the true position was that the Al Tamimi invoice, for example, only related to costs incurred war risk policy, they would have said so in their invoice. And if Al Buhaira was only making a payment with respect to the war risks policy, you would have said so in your tax credit note, but you didn't.
No, this credit actually just for explanation. This will go to, like, for example, when we settle the credit note, we have to go to that particular policy to select that one.
If you go to page 410. So this is credit note, placement slip and credit note. This is for,
My lord, if it helps, sorry, 497 is the actual year of the tax invoice that was sent by Al Buhaira to Audis, and you see the policy number reference on that.
yes. It's the same, it's Hull 114/18/SF. And this is for the war risk policy, isn't it?
Yeah, there's war risk, yes.
So I'm not sure this is a killer point.
Let me put it another way.
This is just an, just for, would you please explain on it? This the code has nothing to do with the policy number. Any code you can put, that is okay. If I want just to be responsible for this account for collecting, I will change, for example, to my colleague name, so they will change the code in the system. So this one just to refer which person has to collect the premium under this policy, just for understood. Not has nothing to do with the policy itself.
Okay, so let's put it this way. When these invoices are coming in and they're being paid by Al Buhaira,
Okay.
isn't the position that nobody in Al Buhaira applied their mind to whether the costs were referable to the war risks or the hull policy because you were treating them as all part of the same legal problem?
See, no. The issue here, this invoice is issued by, like for example, this case which 497 is not issued by us. This is by the reinsurance department. Just to be clear, this one is related to reinsurance, not us, as a technical department.
At 497.
No, this tax invoice, 497.
Sure.
This is prepared by, if you go down, Sajid Babu, this is not related to us.
I think I'm either confusing you or I've been confused, but page 497 is a tax invoice that was sent in 2018 from Al Buhaira to Aris.
Yes.
I'm not talking about that. What I'm talking about is the legal costs, and we saw those
Can you go
schedules.
back, please?
So
But what you're talking about is an invoice for legal costs that bears a reference to a policy number. And 497 indicates that that policy number relates to the war risk policy.
well, let me then try and explain this a bit more clearly. 497 is a tax invoice which has a policy reference SH Hull 000114/18/SF.
That's what was.
But if I understand it correctly, if we look at the actual policy number that was given to the war policy, it was, you can see it at page 488. The policy number was not finishing with the letters SF, it finished with the letters SH.
Yeah, that's fine.
And
That's also during the current of the year. We can change the code. Who will go to be handle this account for the collecting premium?
and
But the number remains same, 114.
114 remains the same, but if you look though at page 504, the policy number for the hull and machinery policy was SH Hull 000113/18/SF. And the point it seems to end up with is that from your point of view, from Al Buhaira's point of view, there was a degree of indifference as to which policy number was being used, because from your point of view it was all the same thing.
No. 114 is for war, 113 for hull.
Okay, and what about
The-
SF and
the
SH?
code, as I told you, the code has nothing to do with this one. And I can change the code now. If I call the company, they will change the code. This anytime you can change. This is only related to collecting the premium, not about the risk itself, about the type of the risk. It's only-
504 is the point that the witness just made, I think. That the hull machinery policy schedule has a policy number 113. The SF and SH appear to be, if I understood his evidence correctly, just an internal reference as to who within the company is actually dealing with the policy. But the policy, the relevant policy number is the 113 or 114.
That's correct.
When you received an invoice from Al Tamimi, who in Al Buhaira decided whether the costs should be attributed to the war risk or to the hull policy?
It's not about a decision. Depending on the instruction regarding what it was. Yani, sometimes this, this Tamim is a legal firm, so they have received instruction from different departments, even from our company. It's not only from Marine. That's why maybe there was confusion addressed to Mr. Isam. Maybe he has another case also.
Okay, well, let's just, I don't want to spend too long on this, but just look at page 945 of the bundle. Page 945 of the bundle, you'll see a invoice from Clyde & Co. And the subject line there is MT Beta coverage advice.
Okay.
Can you see that?
Yeah, I can see.
Now, that invoice, nobody's produced a copy of any billing narrative, but isn't it fair to say that the coverage advice must have included coverage advice on both the hull policy and the war risk policy?
You have to ask Clyde for this, not me.
Well, hang on. You're the head of marine underwriting, the head of claims. You know that claims have been presented under the marine hull and the marine war risk policy. You've gone as far as a DIFC court judgment in front of Justice Robert French to avoid both policies.
Yeah.
Surely the coverage advice was relating to both policies.
It is just related, but the exact which about the address, how they put it, this is from their side. You have to ask them about this, not me.
Okay.
But we know this is the related for the war risk policy. And
Well,
initially,
how do you know that this invoice relates solely and only to the war risk policy?
so we are referring to the case number itself. There are two cases. One CFI to 13, and I think one CFI is 98, which is related to hull.
Sorry, but where do we see that on this invoice?
I think if you gather, no, this is received by email by you. And at the email itself, the email is written there, CFI, is it 13 or 98?
Isn't the position that you've chosen to attribute all 10 million dirham to the war risk policy because that is convenient to Al Buhaira?
No, it's not. As I explained, this we have records actually, whatever related to CFI 98, whatever recorded to this current case. We have record.
The CFI 98, you're talking about the court number,
Yeah, the court number.
the court of first instance legal proceedings.
Yes.
But CFI 98, I think, or whatever the figure is for 2021,
Yeah.
that's a court case relating to both policies.
No, this CFI related between Buhaira and ours. The CFI 13. And CFI, right? This is 98. This is between the cases at all for the whole.
Have you read the judgment of Mr. Justice French?
Yes, I read it. Yes.
You read it. So if we just look, please, at page 869 of the bundle. Can you see, you referred, I think, to CFI 98. Can you see at the top right the claim number CFI 098/2021?
Yes.
Is this what you're referring to?
Yeah.
And then if you look over the page, at page 14, can you see the declarations the court made? The first declaration was the claimant can avoid the hull policy and has no liability for any claim under it. Do you see that?
Yes, I can see.
The second declaration is the claimant can avoid the war policy and has no liability for any claim under it.
Yes, correct.
And then in order that the defendants, so Horizon Al Buhaira Shipping, are to pay the claimant's cost, the proceedings to be assessed by the registrar if not able to be agreed.
Yes.
And as I understand it, there's subsequently been an assessment of those costs for about 5.5 million dirham. Is that correct?
I guess so, yes.
Clearly, even on your version of events, all the costs that are allocated to these proceedings, CFI 098/2021, relate both to the hull policy and the war risk policy.
Yes, of course.
So on what rational basis can you suggest that 100% of the costs should be paid by war risk reinsurers?
It's not about 100% has to be what you see. It is complicated case. I cannot answer you straightforward. This is related to hull or related. Okay. Whenever there are like 100 invoices there, as I told you, this is segregation settled by accounts team. Okay. Our job only just to issue the credit note on behalf of the lawyers, then settlement, whatever related to where, it will be settled by the accounts team.
I mean, it's a matter for argument, but it does strike me that one potential argument is that one would have to incur the same costs in relation to each policy. So if you wanted to, if Al Buhaira wanted to avoid liability under the war risk policy, it would have had to have incurred all of those costs anyway. It's a matter for argument.
There will be an argument about how one approaches issues of allocation
Yes.
or apportionment,
Yes.
of course. But what we know in this case is you are claiming 100% of all of the costs against the war risk reinsurers only. Who reinsures the hull policy for the year 2018?
2018, what is? The reinsurer?
Who were the reinsurers for the hull policy in 2018?
So many people there, I don't know.
So many people.
Yeah, reinsurer you are talking about.
Reinsurers for the hull policy.
Yeah. $70 million, maybe so many people reinsurers.
And all of those people have benefited from your avoidance of the hull policy, haven't they?
Of course they benefit, yes.
Have you asked any of them to pay their fair share?
This is not my part.
Sorry?
This is the reinsurance part, not my part. I cannot answer.
The reinsurance department, you can't
Yeah.
answer that
They
question.
have different department, yeah.
Okay, well, we can make these pointed submissions then. I think, Judge, unless you have any...
No,
Additional
I
questions
mean
on-
that final question was probably the most important.
So, can I move to a different topic, please? In that bundle of documents I'd handed up, there were 3 more post-it notes. I think if you move to the second or the third post-it note, you should find a corporate governance report of Al Buhaira from 2021. Can I ask you to find that, please? Corporate governance report 2021. There's also one there from 2022. Can you see the 2021 there, please?
I can see this.
Can I ask you to look, please, at the 4th page? At the 4th page, can you see a discussion of the members of the Board of Directors as at 2021? And you'll see in the 4th line of the table Mr. Al-Sari's name. Can you look over the page, please, and see a schedule which talks about the experience and qualifications of the members of the Board of Directors? Do you see the CV items or the experience items from Mr. Al-Sari, which indicate that he was Deputy Chairman of the Board of Directors of Al-Saka Saudi Cooperative Insurance Company, Chairman of the Board of Directors of Gulf General Investment Company, Chairman of Horizon Group, Chairman of the Investment Group, Board Member of Al Buhaira, former Chief Commander of Police, former Deputy Chairman of the Economic Advisory Committee of the Ruler of Sharjah, former Deputy Mayor of Sharjah Municipality, former Chairman of Al Saga National Insurance Company, former Chairman of the Board of Directors of Arab Resources for Development. Were you aware that he had all those qualifications and experience?
Well, no, just by reading only.
Just by reading it, okay. And then if we look, please, just 2 pages back. So actually the numbers at the bottom are page 4 of 24. Can you see that under the heading, a statement of the transactions of the members of the Board of Directors and spouses in the company's securities during 2021 using the table below, there's 7 line items. And can you see that the 4th is Mr. Abdullah Juma Al-Sari, member, total sale and purchase transactions NA, total sale and purchase transactions of the spouse NA, total sale and purchase transactions of the children NA. Do you know why it says NA here in terms of share sale and purchase transactions?
No, I don't.
It's possible, isn't it, that he had shares in the company?
No, he doesn't. He's not a shareholder. He's a member, board member.
He's a board member,
No.
but if you look at your witness statement, which is in the bundle, Can you look at page 273 and paragraph 3.2? Your evidence there is you can say nothing about whether Horizon was a shareholder or Mr. Sari's role as a member of the board of directors. It's a public company.
Yes.
So it's perfectly possible, isn't it, that Mr. Al-Sari or Horizon has or had shares in Al Buhaira?
I don't know about these details, but what I know he's a board member.
Okay. And then if we look at the another document in that clip I handed up to you, the corporate governance report, the one for 2022, can you see that in 2022, on page 4 of 34 for the 2022 corporate governance report, Mr. Al-Sari is reported there as member of the board of directors. But then at page 5 of 34, you'll see that during the General Assembly meeting held on 21st of April 2022, a new board of directors was elected. And can you see that 9 members were appointed to the board in April 2022, and Mr. Al-Sari was not reappointed?
Correct.
That was quite a big deal at the time, wasn't it?
I don't know. I have no comment because I'm not involved in this elections.
You're not involved in that. Okay, now the fourth document in that clip, I just want to show you, moving on to a slightly different topic, is an extract from your company's website. Can you see a document that starts, "We insure both the physical loss and damage to hull and machinery," with a picture of a blue ship on it, a sort of cartoon picture? Can you see that?
I can see it.
And are you familiar with the material on your company's website?
Yes, it's being changed continuously.
It's continuously changed and updated, but can you see under the heading at the bottom, Marine Hull Insurance, Al Buhaira Insurance, commercial vessels involve a variety of crafts operating either in Arabian Gulf, Gulf of Oman, Arabian Sea, and Indian Ocean, or worldwide, whether a fleet or single vessel. We insure both the physical loss and damage to hull and machinery and collision liability arising out of the ownership and operation of vessels as per London Institute hull clauses. Now, do you agree that the policies that you issue have at all material times been subject to London Institute hull clauses?
Yes,
And it follows from that that they've always been governed by English law, doesn't it?
the clause policy itself is English. Yes.
English law. And if we look to the third page of that clip, a further reference to the London market, at the top of the third page, coverage can range from hull and machinery and total loss as per London Market Institute time clauses, depending on the needs of our clients and risk evaluation. The insurance coverage on an agreed value basis. Now, towards the bottom of that page, can you see it says there are other coverages available. We shall be happy to provide you with further details as and when required. Now, nobody at Horizon or Al Buhaira International Shipping Inc. ever asked you to underwrite the insurance policies with them on anything other than English law, did they?
No, this nobody involved. They're not involved at all in the operation.
No. So if we look, please, in the bundle at the 2018 policies, we'll see one. We've I think just looked at it, but we'll see the hull war policy. Can you see, please?
Which page, please?
Sorry, page 488 is the policy. Can you see the Marine Hull War Policy schedule?
Yes, I can see.
And this is the one from 2018. Can you see on the second page, at page 489, next to the word cover, Institute War and Strikes Clauses, hull time dated 1/11/95, CL 281.
Okay.
You're familiar with those Institute
Yes.
clauses?
Yes, I'm familiar.
And you agree those Institute clauses are governed by English law and practice, don't you?
Yeah.
And all the other Institute clauses and London Market clauses refer to in these clauses, conditions below, they're all governed by English law and practice, aren't they?
You mean all this below that one?
All the clauses. So the first one is Institute War and Strikes clauses, hull time 111.95. The second one is including war P&I as per Institute Protection Indemnity War and Strikes clauses, hulls time 2004.87. Each one of these, the piracy, violent, theft, and barratry wordings, they're all governed by English law and practice, aren't they?
Yeah, this is subject to London market.
Subject to London market. And then when you go over the page, in page 490, there's a clause there that says this contract shall be governed by and construed in accordance with English law. Now, that reflected the position that prevailed in 2015, didn't it?
Yes, of course. This is clauses all related to London market. That's we have no objection to that one.
Yeah. So even if this clause was included as a belt and braces extra, it didn't change the governing that existed in 2015.
Governationally, the United Arab Emirates.
Sorry, where do you get the proposition that the governing law is the United Arab Emirates? You just looked at the clause that says English law.
No, if you read this one, this contract shall be governed and student in accordance with the English law. When you say this contract means the contract between us and the client. We're not talking about reinsurance here.
Sure.
Okay? And then each party, which means Buhaira and each party, between Buhaira and the client, had to go to the exclusive jurisdiction of the courts. I don't want to explain, but the court of the UAE and any disputes, which means the clauses itself interpreted by English law. But any disputes related to claims or expenses has to be subject to UAE courts applicable. Whether jurisdiction, whether because the UAE courts has oversight like for all other courts, all other laws.
Okay. We don't disagree if you look at page 489 that this has a jurisdiction clause for the United Arab Emirates.
Yes, correct.
But you're not suggesting, are you, that the jurisdiction clause United Arab Emirates suggests that United Arab Emirates governing law applies?
No, because jurisdiction itself is defined as per in that law. If you go back again to that one, go back to
Now, so you're aware, are you, that there are two different legal concepts here? There's the governing law of the policy,
yeah.
and there's the jurisdiction in which any disputes will be heard. So I think the suggestion is, yes, if there are any disputes about the policy, they will be decided by the courts of the UAE. But if there are disputes, they have to be determined in accordance with English law. Do you accept that as an analysis?
No, sorry.
Okay. Well, I'll leave it to counsel
Well,
then.
time is short, but what I'm going to suggest to you, in the interest of time, is that the Hull war policy in 2015
Yeah.
was clearly governed by English law.
The whole policy, as I told you, the clause itself between us and the insured, not the reinsurer.
Okay.
So you have to
Listen,
be clear
listen to the
about
question, please.
Yeah, I'm listening.
Mr. Shalab. The Hull war risks policy in 2015
Mhm.
between Al Buhaira and Abnick was governed by English law.
Between Al Buhaira and
Sorry, Al Buhaira and Horizon
okay,
was governed by English law.
yeah, correct.
Correct. And the 2018 Hull war risk policy was also governed by English law.
Yes, covered by the clause itself. I'm telling you again, the clause itself, it's subject to English law. The clauses, I mean the contract between us and the client.
Precisely.
I'm not joking, just going just to tell you. But
So between 2015, the war risk policy between Al Buhaira and Horizon, which was governed by English law, and 2018, when the policy was governed by English law, there was never any change as regards the applicable governing law, was there?
no, the governing law is always UAE.
Sorry, we just
Yeah.
started with the proposition that the 2015 marine war risk insurance policy,
It is English law.
English, you
Yes.
agree with that?
Yeah,
And the 2018 war risk policy is English law.
yes.
That's what he means by governing law.
No, because I think I didn't get his.
No, no, no.
question.
These are English phrases, English technical legal phrases. Governing law means the law of the policy. So the law of the policy is English law,
Okay. And the disputes?
UAE.
Yeah, this is what I'm trying
Yes,
to say.
so I think when you disagreed with me before, I was a bit surprised because I think we're all in danger of agreeing with each other here.
Yeah. Yeah,
Okay.
you're right.
Okay, so I'm not,
Because maybe I hear it in a different way.
Yes, of course. I'm sorry. We're using technical legal phrases that you may not be familiar with. I apologise.
I don't want to confuse you. I want to make sure we get it right. The institute clauses, just for the sake of, to make sure we're on the same page. Have you seen the institute clauses yourself?
Yes, of course.
Okay. So can we look, for example, at the institute clauses that you see at page 400 of the bundle? Can you see at the top of page 400, under the title,
Yes.
it says this insurance is subject to English law and practice?
Yes.
And you're aware of that when?
I'm aware of this.
Okay. Were you aware of it in 2012 when you joined Al Buhaira?
No, this is actually international clauses. It's not about specifically here. Anytime you can see this clauses there. English law is there for all clauses.
English law is there for all
Yeah,
clauses.
for all marine clauses, English law.
And you know that both your business and Arab war risks provides hull cover in your case and war risk cover in their case on the institute clauses which are governed by English law and practice. You know that?
Yes, this one is okay.
Yes. So in 2015, when your company provided a war risk policy to Horizon, can you look at page 418? At page 418, 419 and 420, you will see the policy wording. You can see, if you look at the bottom of 418, the trading area is worldwide subject to London market war risk trading warranties. And you can see under the word, next to the word cover, Institute War and Strikes clauses, Hull's time dated 1/11/95, CL281. You knew that the governing law of this policy was English law, didn't you?
Yes.
Yes. And then to go back to the 2018 policy, which is at page 488, you also know that this 2018 policy was governed by English law, don't you?
Down, please. Just read it. Down. Yes.
Yes.
Clearly written there.
Okay. And that clause at page 490, it wasn't introduced to reflect any change in the governing law, was it?
This clause in board 490.
At 490, under the words law and jurisdiction, the clause was not put in to reflect an agreed change between Horizon and Al Buhaira. There was no change in the governing law, was there?
No, there is the same, yeah.
The same.
Almost the same, yes.
Okay. Now, the position follows from that, doesn't it, that the reinsurance agreement between Al Buhaira and Aris has always been governed by English law.
But no, it is UAE law.
But let's look at the reinsurance cover note, can we?
Because I think the reinsurance team can answer that question better than me.
Okay. Can we just look at page 415 to 416, please? Can you see that the wording at page 415 is mostly taken from the wording of your insurance policy? And if you look at 415,
Okay.
the word trading area, worldwide subject to London market war risk trading warranties, and the cover 1, Institute War and Strikes clauses, whole time dated 1/11/95, those are all referring to precisely the same London Market and Institute clauses, which are all governed by English law. There's no suggestion of any different governing law in the reinsurance, according to this reinsurance cover note, is there?
This one actually came by ours, not by Buhaira.
Exactly, came by ARIS.
Yeah.
And the way it works, actually, is that ARIS,
This is prepared by ours,
this is prepared by ARIS, but it's
according to our policy.
according to your policy.
Yeah.
But your policy is created because you receive from ARIS technical updates even before the policy is written, telling you what clauses to include in war risk insurance policies.
No, it's not that. That's not correct.
So-
We are offering ours. They are accepting share based on our terms.
You're accepting war risk
Yeah.
insurance on your terms.
Yeah, whatever we are offering, they are accepting them. This is the procedure.
Well, can you just look back at page can you look through to the 2015 insurance policy wording?
2015.
So if you look at page 420, why would you include in your policy an ARIS missing vessel clause?
Why?
Yeah, why?
Go back, please. Where is that one? I can't recall actually if you go why we included that time. We have to go back because this reference came by ours, not by us. Sometimes when you send the slip to them, they will go to do some amendments. They will accept that slip based on their amendments.
But that's not reflected in their reinsurance cover note. Can you look at their cover note at 415 to 416?
That's I'm telling you, that is prepared by ours, not us.
Right. So the reality is, the way it works is that,
And if they miss something, if you go to this cover note, they are repeating many clauses also. And they're
but the
all
way it
saying-
works is that your company finds clients who want to buy war risk insurance from you, but you sell it to them on institute clause issued out of London, governed by English law, which you are required to do by ARIS before they're willing to provide you any reinsurance.
No, see, usually the issue here, just to more explanation, just let me explain this one. Before we confirm or before we buy an insurance, we have to get support from the reinsurance themselves. So reinsurance will read the terms, our terms, which will going to be offered to the client. In case they satisfied, so they will offer and they will take share, for example, according to the terms prepared by the technical department. Okay. Once they agree, this will go to be offered to the client. Okay. This is what the procedure just between us and between ours.
And you know that ARIS have got retrocessionaires in London, in the London reinsurance market, don't you?
Sorry.
You know that ARIS buys retroceded coverage from
Yeah,
London.
they are okay. Reinsurance, they are syndicate, of course. They have something from London. That's of course.
They're a
Sorry.
They're a syndicate.
Yeah.
Your company's a member,
Yes.
and they in turn buy reinsurance from London. You know that.
Yeah, of course.
Okay. So your concern when underwriting is to make sure you have back-to-back cover with your reinsurers, and that they then have back-to-back cover with their reinsurers.
Yeah.
And the only way back-to-back cover works is if it's all governed by English law by reference to institute clauses. Isn't that correct?
Yes, as I told you, the cover itself, the terms itself is covered by the English law, but disputes as the registered jurisdictions, United Arab Emirates, will be governed by the UAE.
Okay, I'm just going to move on to another topic now, but can I ask you please to look at page 405 of the bundle. Can you see an email there from Mr. Mohammed Al Sheikh to Ghassan Hamama, which you were copied in on? Mahmoud Shalab
Yes,
is your
I
name.
can see.
Do you remember receiving that email?
I saw this email, yes, but okay.
This email was an email where he was following from an earlier email. Maybe it's easier to look at the one earlier email at 406. can you see that he sent a message with high importance, referring the above account? We've received a firm order from our client to ensure his marine hull war and P&I policy of our company, details of which, as per the attached underwriting information, needed to confirm your 100% fact support the highest commission possible. Your urgent response will be highly appreciated.
Okay.
Were you the person who had secured that order from the client?
Yes.
And did the client at the same time order or require marine hull and machinery insurance, not war?
No, they inquire for all. This is a bundle, all policies together, as a package, all policies.
They wanted as a package.
Yeah.
So did you at Al Buhaira
We received for all policies. It was actually not only one. It says almost 5 policies.
5 policies?
Yeah, not only 2. There are, but that is not related to ours.
So what were the other 3 policies?
That's an offender, some small things. I don't want to go into details, but that's only small things. And cargo policies sometimes. And
Okay, but in the course of agreeing to underwrite them in May, did you agree that Al Buhaira would give them a hull and machinery policy for the fleet in 2015?
to give to whom exactly?
To Horizon?
Yeah, to give all policies, not only Harlem machinery. Harlem, das war, das Dodger boys.
So you agreed to give them all risk cover, including war risks.
Yeah.
Who were you buying the reinsurance from on the other 4 policies?
I think you have to ask the reinsurance department.
Ask the reinsurance department where they get the reinsurance from, not you.
Yeah, we are okay sometimes, but they are more related to them, not us. We are the technical part with the clients.
Now, why was it urgent?
What is what urgent?
Why was this urgent, this email?
I don't know. As the guy who prepared it, not me.
Okay, but you were copied in, and you were the underwriter for the.
To secure
Client.
maybe to secure the support or to secure whatever, because it were close to the renewal that
Okay.
time.
So it's not as if you or they had a long period of time to negotiate terms. It was so urgent, essentially you would just take the standard terms, wouldn't you?
Yes, but I cannot comment exactly why it is urgent, because that time why he sent that email. Maybe you can ask the guy who prepared that email why he mentioned it's
Okay.
urgent.
So I think he's next.
There was-
He's next, so I'll ask him
Of
next.
course. There was time I've seen that time till the renewal.
Can you then look at 405? Can you see that he then suggested amendments to paragraph 9 in the policy schedule? Can you recall why he suggested those amendments to include further references to institute clauses?
Maybe it was missed that time from the terms which we sent to ours that time.
Do you think you would have checked that yourself?
Maybe it was sometime, this is...
Okay. Now, the document that he seems to have attached is the one at 407. Can you see that? 407?
yes, I can see.
Have you seen that before?
Of course, yes.
And that's prepared, isn't it, by Al Buhaira?
Yes.
Can you see the second item is reference to the beta?
Yeah.
Can you see the flag that is said there is Liberia? And the class that is put down in the class column is LR, Lloyd's Register.
Yes, that's correct.
So was it your understanding at the time that Mr. Al-Sheikh wrote to Aris that the tanker was classed with Lloyd's Register?
Yes, according to the schedule which we received from the client. It was a class that time with the...
But this is a schedule you've prepared, though, isn't it?
This is we prepared according to the information received by the client.
Okay, but if you look at the right-hand columns, you can see there's a rate column and a premium column.
Yeah.
Those are calculations that Al Buhaira has made.
Yes.
So that's not information that's come from...
No, up to ship owners and the sum insured, that came by the client,
Okay.
including the crew. After that, the calculation is our part. And this is, by the way, it's only for crew. It's not for hull. This is the crew schedule.
This is the crew schedule.
Yeah, only for crew calculation.
So when it says war crew P&I fleet,
So the sum insured showing here is not related. It's 70 million, but this calculation is related to the crew.
I'm not sure that can be right, because if
No,
you look...
go to the left, it's written there, in the left. in
No,
the
no,
top
but
left.
if you look at the column for sum insured, you can see the supposed sum insured value for each vessel.
Yeah, $70 million, yes.
70 million, and the rating of 0.185% and the premium calculation is calculated by reference to the war risks, all classes of the war risks in the policy.
Yes, that's for the crew, yeah.
But it's not just for the crew, is it?
War crew, yeah, I mean war crew B&A, what we call it.
Okay, so that's the list you've prepared in 2015, in which you represented to Aris
Yeah.
that Beta was classed with Lloyd's Register.
Yes.
And can you see all the other classifications in this list? Some of them, for example, number 10, the Lowdale, at number 10, Lowdale X Gamma 2, that is flagged in Palau, but it's classed with Bureau Veritas, BV. Yep. Okay, now can we look please at page 412? At 412, we can see a document which is dated the 10th of June 2015, and at the bottom it says for Al Buhaira National Insurance Company. This has been prepared by Al Buhaira, hasn't it,
Yes.
this document? And you can see that it is, at this point, a list attaching to and forming part of policy SHL 000114/15/SF, and it had been sent along with the premium closing calculations that you can see. The credit note is at 410 and 411. Do you agree with that?
Yes.
And on this document, you can see that the beta is shown as classed with Lloyd's Register. Do you agree?
Yes, agree.
And it's flagged in Liberia.
Yes, correct.
And number 10, again, by way of example, the Lowdale X Gamma 2 is flagged in Panama and classed with Bureau Veritas. Now, can I ask you to look, please, at page 414?
Same basis.
This appears to be a similar document.
Repeated.
Repeated. Can we look now at page 417? And at 417, you'll see the schedule that was attached to the Auris cover note, but again, based on the information you had provided to them.
Yeah.
And so you can see the number 2 beta is again flagged Liberia, class Lloyd's Register.
It's the same actually, by the way.
It's the same document that forms part of the reinsurance based on your representations to them about the classification of the vessel with Lloyd's Register.
Yeah. On that year,
For that year.
in 2015, yes.
Now, if we then go, please, to page 421. 421 is a document dated the 8th of June, which is issued by Al Buhaira and stamped by Al Buhaira. And it's forming part of the policy for 2015 for the whole war risks. And again, you can see the vessel, beta number 2, the flag, the class. Can you also see the IMO number? The list in the IMO,
IMO number, yes,
IMO
I can.
numbers. So you had the IMO numbers for each of these ships, numbers 1 to 16.
Yeah.
And you do know it's very easy with an IMO number to search online to find the current status and classification status and flag of a ship, don't you?
Actually, it's not our part. It's not our duty to search for details.
Well, it is actually, isn't
We
it?
can just check to confirm that the number is related to that vessel. That's fine. It's our work. We can check.
What
But
you
other
actually,
related things like whatever to the vessel is not our duty. It has the client to provide it to us, not us.
the client has an obligation to provide it to you, but you also have an obligation to provide it to reinsurers. And in the course of that process, receiving information from the client and double checking it, and then passing it on to the reinsurers, you do have an obligation to check, by reference to the IMO number, the status of these vessels.
No, as I told you, we have no obligation as Buhaira to check. It's not our duty to check or to provide such information. But whatever we ask to the client to provide us, the client has the duty to provide, to disclose all this information from their side to us.
Okay. Can we now look, please, at page 474? Can you see at page 474 a spreadsheet which was prepared by Horizon?
Yes.
And that lists 20 ships. Can you see that?
Yeah, I can see.
And this appears to have been attached to an email which you find at 473, dated the 4th of June 2018, to you, Mr. Shalab.
Yeah.
Can you remember why Ms. Rama sent this to you out of the blue?
Sorry?
Can you remember why she sent this to you out of the blue?
This one?
Yes.
This one, of course. This is when there is renewal. At the time of renewal, they will submit this one to us.
So had you asked her to send it to you, or she just sent it to you without
No,
request?
usually they are sending, and sometimes at the time before renewal, we are asking them to provide updates. Okay?
Okay.
Then if there is anything from our side to us, then we will ask them.
Well, can we just see, if we look at the schedule she sent to you for the beta, can you see
The
that,
initial one, not the
can you
last
see the beta,
one. Beta, okay.
in the penultimate column from the right at the end, she's now said the class is BV, not Lloyd's Register.
Yes, because this one is 2018.
It's 2018,
Yeah.
but isn't that showing a change in the class from 2015, when she was telling you it was registered with Lloyd's Register?
No, because 15 it was Lloyd Register, and every year this class is changed. Sometimes there is no compliance with the whatever the maintenance class will be withdrawn or will be suspension. So that will be changed with other class. At that time, 2018, the class changed to BV. That time, okay, but it was not. We don't know. It was a class or not a class. Whatever information received from them, they inform us this vessel under BV.
Okay, as it happens, what we know from, for example, the judge's judgment in
Yeah.
DFC, in February 2016, the beta was taken off the Liberian register. It was no longer registered in Liberia. And in 2016, it was taken off the Lloyd's register.
Yeah.
It was never put on the Bureau Veritas register, was it?
Yeah, it was not under BV.
Not under BV.
It was not class. Yes.
And she's giving you a schedule which is telling you that it's with BV, when you know that it's before, it's meant to have been with Lloyd's Register.
No, we're not. We don't know. I was not aware that it was not.
Well, you must have been aware, because you told the reinsurers in a schedule that it was with Lloyd's Register.
No, that is the information received by the client.
But you're passing it on to reinsurers to buy reinsurance.
And we ask updates every renewal. We are asking for updates, and we are providing the reinsurance. Whatever. This is the final step. When we inform the reinsurance, this is the final information.
Okay, now, you know I was asking you about another example on the schedules that we looked at previously, number 10, ship number 10. If you want to go, well, if you want to go back, for example, to page 417, can you see at item number 10, we looked at the Lowdale X Gamma 2,
Yes.
and that's year of build 1991, Panama BV.
Yeah.
If we compare that with the schedule that she's sending you, that we're looking at 474, that ship, if I've got this right, seems to now be the Mercury. Is that correct?
Can you go back to the
Number 8, the Mercury. It's been renamed.
year 20?
It's got the same year of build and the same tonnage.
Yes, probably it is the same. Depending on the IM.
And can you see that what's happened is that it's changed its flag status from Panama to Palau, and it's changed its classification from BV to LR?
Yeah, that's what is the issue of this one. Anything can happen during the year.
So you're receiving a schedule in 2018, which is showing you different number of vessels. It's gone from 29 to 20. Some of the vessels are changing their names. Some of the vessels are changing their flag. And some of the vessels are changing their classification
Yeah.
entity. Can we then look, please, at page 475? 475, there's an email from you of the 4th of June 2018 to Emilda Rama, which seems to follow from her sending you the updated list of vessels, in which you say, I was about to send you an email regarding the status of renewal.
Yes, correct.
That suggests that you hadn't been emailing her previously about it, but she was the one who'd emailed you. Do you agree with that?
No, we used to send usually our team, my handling team, they are sending prior like 30 to 45 days. Renewal reminder, what we call. And whatever, if there is no reply, so then the client, sometimes the client will come one step ahead, then he will send us the information before we ask.
Okay, well, can you look over the page at 476? You emailed her to say, anyhow, kindly confirm clean loss records to date, along with the updates in respect of vessels Larnaca 77, 88, 99. According to the market, those vessels already sold in auction and transferred to new owners.
Yes.
Now, just pausing there, doesn't that suggest that you actually were doing checks behind the scenes with respect to the vessels on the list to check their class status, their ownership, and you could do that by reference to IMO numbers?
No, that is not actually, in particular, if you need clarification, that 3 vessels, actually this is came by like somebody wants to buy those vessels. He called us, he informed us. We are not checking, but he said we saw this vessel in one. So somebody wants to buy those vessels.
But so you felt, if nothing else, you had to ask for confirmation of clean loss records and also confirmation of ownership status. Is that right?
Yeah, because when we got the information that time, then we asked about it just to reconfirm whether those vessels sold or not sold.
Now, can I also look at the email at 475, the 5th of June 2018? 475, from you, Mr. Shalab, to Emilda Rama. Dear Emilda, further to our below email, would appreciate to send us the status of class for the existing fleet and advise if there are any amendments. Appreciate receiving a reply as soon as possible, as the time is very short, and we need to update our reinsurers ahead of time.
Yeah.
So that indicates, doesn't it, that you understood the importance of knowing the class status for the whole fleet.
Of course.
And that's in circumstances where you were being told that at least 2 of these vessels had changed their classification status from their previous classification status.
No, but this is what can you repeat please again just to...
You knew the importance of
What
asking...
exactly you need to know from me to answer you correctly?
Sure. Do you agree
Yeah.
that when you sent this email in 2018,
Okay.
you knew that it was very important to ask her about the class status for the entire fleet?
Yeah, of course it's important, yes. I agree.
And the reason you were asking for that information is because you knew you had to update the reinsurers as well.
Of course, yes.
And when you sent that email, you knew that there had been changes in the previous classification status of the vessels, because if you looked at the previous schedule, it said Lloyd's Register, and now it's showing Bureau Veritas for one ship, the Beta,
Yeah.
and then for another ship, which has changed its name, it's showing LR, Lloyd's Register, instead of Bureau Veritas. So at least 2 ships are changing classification status.
No, it's not about these 2 ships. See, when we ask for updates, we are talking for the total fleet, not about for 1 vessel or 2 vessels, okay? And 2016, I think the BV became BV in 2016, according to the client, what he told us that time. So every year we're asking for updates, not only for this particular, not only for this client, by the way. All clients we are asking about the updates, about the clean loss record. Every year we are asking this information. So the update, whenever we send it to them, the same, just to clarify, the same list what we have, we are sending to the client, and please provide updates if there's any updates. You know, sometimes during the year there will be changes for the class, to the whatever there. Maybe the client he didn't inform us, he's not updating us. So at least just to give them chance to update before the renewal.
So can you see her response at page 478?
What about renewing the class?
At 478 at the bottom, she responded to you on the 5th of June to say, please note, we are in the process of renewing the class.
Yeah.
Kindly renew the policies. Now, what she was telling you there was not that the vessels were in class, but they're in the process of renewing class.
What I could understand from that email is the renewal of the classes has been initiated that time, which we rely on that email from her.
But you didn't understand her to be saying that the vessels were in class, because that's not what she was saying.
Yeah, she will proceed in renewing. It means she's doing the renewal for all class, for all vessels, doing the renewal.
Now, if you look up at the next email at 478, your response was noted your email, but again, we need to answer our reinsurers regarding vessels Larnaca 77, Larnaca 88, Larnaca 99.
Yeah.
Were you being asked by the hull reinsurers about those vessels?
Not exactly, but sometimes, of course, if we remove those vessels from the list, the insurance will raise questions. So we have to be ready, you know.
Okay. And then if you look at page 480, can you see, please, there, her email to you, reference to the attached list of vessels, kindly proceed with the renewal of the policies issued them accordingly. However, please hold the renewal of the below mentioned vessels, and she's naming now 3 Charge of Pride, Gulf Glory Sea Spirit, and the tugboats, Larnaca 77, 88, 99. So we'll advise you about them by 9th of June 2018. She never came back to you, did she,
No.
to say that the renewal of class had been completed?
No, she didn't.
She didn't. And can we look now, please, at page 683 of the bundle. At 683 of the bundle, we'll see a document that Al Buhaira National Insurance Company prepared. Isn't that correct?
Yes.
So it's your document, and you can see it's War Crew P&I Fleet 2018.
Yeah.
And we can see the vessels here listed, including the Beta at number 2, with the flag Liberia and the class BV. At the far right, the rate and premium. And on this schedule, would you agree there are 20 vessels?
20 without the 3. There are 3 vessels removed.
Well, somebody has written, we don't know who, in handwriting, XXX.
No, because this is not the final step. This only,
Well, I'm just going to,
it's a draft one, this one. It's not the final.
well,
The final one, you can go for the final step.
this document was actually attached, wasn't it, to an email from Al Buhaira to Aris, dated the 7th of June 2018. Do you agree with that?
7 June. Can you go first? You have it. Which page?
Page 437, isn't it?
Thank you, my lord. Let's just check. Yeah, so it's the bottom of page 437. Thank you, my lord. Can you see the email from Sajish Babu to Entisar Atea?
Yeah.
And you were copied into this. Thanks for your below email. Please find attached updated schedule for 2018-2019. Would appreciate a reconfirmation of 100% share to enable us to proceed further. And that had followed some earlier emails in May about the provisional renewal agreement.
Yeah, but that's not the same one which you showed me just before.
No, what she sent was that document dated the 5th of June, at 683. So what Mr. Babu sent to Ms. Atea was the document at 683.
No, but the 683, this is not related. I mean, the 3 vessels already removed. 17 vessels into ours.
I think you may be mistaken about that.
It's not, no, it's not mistaken. This is only draft. It's not final.
You are mistaken about that, because that was the document that was sent by Mr. Babu on the 7th. What then happens
How
is...
you confirm that is the same?
Sorry?
How you confirm this is the same?
Well, these are your documents.
No, but the attachment, where is the attachment? Is this
But that's the attachment.
This what was attached there?
That was the attachment to that
Okay,
email.
but it's already showing there is X, which means that 3 vessels not included.
That was marked up subsequently by somebody.
No.
So let's just go...
You have to go just check the final declaration. This is not this.
Well, hang on. Can you see that if you go back to 480, she had written to you on the 6th of June, after the 5th of June, to say, proceed with the renewal of the policy issued accordingly. Please hold the renewal on these three plus the Larnaca ones.
Yes, correct.
Right? And what then happens, if you look at page 484, page 484, she emails you on the 10th of June, which is the inception date of the renewed policy. Please find the updated list of vessels for the policy renewals.
Yeah.
And then, as I understand it, Noble, some brokers get involved on the 11th of June, which is at page 485.
That's correct.
And now this is after the commencement date of the policies.
Yeah.
We attach here with the updated final list of vessels relating to the fleet received from them. The names of the owners and managers are mentioned in the list, hence the renewal of the hull and machinery policy may be effected on the basis of this list. Kindly confirm cover. You agree with that?
Yes, I agree.
And you forwarded that email to Mr. Kadumi, is that correct?
Yes, correct.
And the document that was then the final list is the one that we see at page 487.
Yes, this is the final.
Okay? So that's them sending it to you. Now, if I'm understanding it correctly, you then issued a war risk policy to them on the 28th of June 2018. Can you see this at page 488? Yes?
Yes.
And this was now 18 days after the inception date of the policy, so you included at the bottom of page 489 as subject to no losses from 10th of June to 28th of June clause. Is that correct?
Yes, correct.
And the schedule that was attached to your policy that was signed by Mr. Kadumi is at 491. And this now includes the Beta, of course, but also the 3 Larnaca ships, but only 17 ships.
Yeah.
So it doesn't include those other 3.
Yes.
Now, it's not until then, the 12th of July 2018, that your accounts people sent the placement documents to ours. Do you recall the reason for the delay?
I don't know what.
And the documents they sent are the ones at 496, 497, 498 and 499. Can you see that at 496 it's dated the 28th of June? And just look please at the schedule at 499. You've got there 17 ships, including the Beta, in which you're telling Aris that it's flagged in Liberia and classed with BV.
Yes.
But you never told Aris, you never told them that, in fact, it was not classed, but you had been told it was in the process of having its class renewed.
Because I was not aware about the class status.
But you had been told by Horizon's representative
Yes, you're right.
it was in the process of
They
being renewed.
informed us, they confirmed the vessel is BB class, and we should have policy based on that one.
But you did
Because the
tell
vessel
them,
wasn't class. This is not the matter that we are aware about it.
you did tell that.
Sorry, just pausing there. Can we go back to page 484? You've just suggested that Avnik was told that the Beta was in the process of being renewed, its class is being renewed. But Beta is not mentioned on page 484.
No, I'm sorry, it's page 478 you need to look at.
478.
478 at the
I missed
bottom.
the reference.
Please note we are in the process of renewing the class.
Yes, but isn't that that does not specifically refer to the beta, does it?
It is referring to the beta. It's
Why
referring
is
to
it
the entire
referring to the
fleet.
beta? I mean, this is the 5th of June. The correspondence about the 5th of June. So, what is the context of that renewing the class? The response is in relation to Larnica, and then the 6th of June they say omit then those 6 vessels.
Just if I can assist, if you look then at 475,
Yeah.
the question that had come from you, Mr. Shalab, was appreciate to send us the status of class for the existing fleet and
Okay.
advise if there are any amendments. You were asking about the whole fleet
Yeah,
of
the whole
vessels,
fleet, yes.
the whole fleet.
Okay, then it's my fault.
And so when she responded to say we're in the process of renewing the class, she was talking about the entire class that was being renewed,
For the entire fleet, yes.
the entire fleet,
Okay, so that's accepted.
so including the control. And, my lord, I'm conscious of the time, but if I can just try
No,
to finish
no,
this
no,
topic.
that's fine. That's fine.
Now, when you, on the 12th of July, through your accounts team, forwarded the final schedule, you didn't tell them that you had been told, sorry, you didn't tell Aris that you had been told that the class status was all subject to renewal, did you?
Subject to
Subject to renewal. You didn't tell
the
Aris.
same what we received from the client, you mean? We did not inform ours whatever we received from the client, the same wording, you mean?
Well, so just to be clear.
We have the process of renewing the class. We understood the class is being renewed means it's already, the renewal already initiated, which what they understood from
Renewation. But you didn't tell Aris. You didn't tell Aris. By the way, there's a slight footnote or a slight problem because we're telling you all these vessels are classed, but we haven't checked it, and we've been told that there's a renewal process underway, and so there may be some concerns about this. You didn't say that to them, did you?
No, this is not our duty to tell.
Okay.
Because
Well, can I ask you then, when it came to the hull insurers, isn't the position that you did tell the hull insurers that there was a problem with the class?
well, no, we were not, we were not informed.
And that's why in the hull policy, if you look at page 505, that's why at the bottom of 505 under warranties, in addition to the existing warranty in the institute clauses, the reinsurers for the hull policy asked you to put in a additional express warranty that the insured was warranting that all vessels were IAS classed and existing class maintained throughout the policy period.
Yes.
So you had told the hull reinsurers there was a problem with class, but you had not told ours that there was a problem with class.
No, I did not tell anyone about this. See, whatever received by client, this information has to be disclosed by the client. The client will confirm that he initiated the class process, renewal. So based on that one, we understood the class is being renewed, which is renewed. Yeah, means all vessels now a class according to the final declaration which they submitted to us. Based on that one, we submitted the confirmation to all reinsurers. And of course, if there is any doubt, the reinsurers, of course, they will ask question, whether any updates or any something. But since no question received, they accept it as it is, the declaration.
Now, if you look at the policy schedule that was attached on the hull policy, can you see at page 507, can you see there the hull policy only had 9 vessels on it?
Yes, correct.
Why was that?
Because this is only the commercial ocean going. As I told you, there are many policies, not only two. Some policies only pleasure yachts. Some of them is small, which is within our capacity coming. So we are assuring separate policies for all,
Sorry, so there is yet another hull policy which has not been disclosed to us,
No, no, no.
that relates
That
to
is
the
small-
balance of
it
the
is
fleet?
not hull, it is like small pleasure yachts. Like one boat out of that one. It is Majid, what we call, the name is Majid. If you go back to the list, it is already written there. That is totally different terms. But for the client purpose, we are putting as all one schedule, you know. Even the client provides the final declaration showing as one schedule. But when we issue here, we are segregating. As I told you, there is fenders, there is pleasure boats, there is all machinery.
Okay, and then just to
And
be,
I think it's already in the bundle, but I can see the all policies there.
and just to be clear, on this schedule at 507, can you see that you've included the IMO numbers in the third column for the vessels,
Yes,
as well as the flag and the class,
yes, correct.
as well as the premium calculations in the far right?
No, that's the premium. This is deductible.
Sorry?
It's not premium. It's deductible.
Deductible,
Deductible, not premium.
sum insured, and
This is
deductible.
deductible, not a premium.
So can you explain that?
Means this deductible means whatever the client has to pay during any claim. You know,
Okay, so
it's not a premium.
You've got the sum insured and the deductible, yes.
Sum insured, deductible, close 12, then
Right.
machinery damage, additional deductible.
okay, so that's Horizon's deductible, 65,000 per ship.
Can we be moving towards a break?
Yes, of course. Well, my lord, I just want to, I mean, it's very easy if I try and wrap up, but just if I can ask this one further question.
Yeah, I don't suggest you finish your cross-examination.
Well, in which case then, if we break, and I'll try and be very quick after the break.
Okay.
And my goal, I know Mr. Craig is going to try and get me to hurry up. My goal is obviously still to finish the other witnesses for the claimant
Well,
today.
we'll take stock after this witness.
Yeah, well, with respect, it needs to be more than the goal. It seems to me that there has to be as witness today. So as to finish the factual witnesses by lunch, it hasn't been one witness.
Well, again, we can look at timings of sittings and so on, as we discussed yesterday. So I'm afraid you're not allowed to talk to anybody about your evidence. You're still sworn on oath on the stand. So may I suggest, I regret that you have a lonely lunch, and we'll come back at 2:10.
10 past 2.
Yeah. Okay, but you must not speak to anybody about your evidence while you're still in the witness box. Okay?
Sure.
Okay. All right. Okay. Well, we'll resume at 2:10. When we finish the witness, we'll take stock of the timing, and perhaps we might sit till 5 this evening, but we'll have to think about that.
We'll have to think on that because I need to go talk to the.
Thank you. Mr. Shalab, can I ask you to turn back to page 419, please? 419 of the bundle, which was the 2015 Hull War Policy that was issued by Buhaira to Horizon. If you look at page 419, towards the top of the page, can you see the words premium as agreed?
Yep. You can see.
Why was that clause included in the war policy?
That is actually common from the system company.
It's common
Yeah.
because that's how you identify what premium Horizon was due to pay Al Buhaira. Is that correct?
No, because the premium already mentioned in the tax invoice itself.
So
there
it's
is no
agreed.
need.
It's agreed
No, it's part of the policy.
part of the policy.
When we submit the policy, it was sent the schedule along with the debit notes.
Policy agreement. Okay. So
The premium already identified there, it's already the same premium.
and can I ask you then to look, please, at the 2018 policy schedule, which, if you look at page 489, if you look at the same effective page, at page 489, will you see that there's no line entry with the word premium, is there?
Yeah, that is the system issue.
Why would the system produce a different policy in 2018, deleting the words premium?
Because, you know, there is a bug error in the system sometimes. And sometimes the team forget, like, for example, to put some notes in that one, it will not appear in this one. Can you go down, please?
If you look at page 491, the schedule that was attached to the policy, there was no premium calculation in that document, was there?
Yeah, this is not the premium calculation, only just for the information above the fleet.
So the position actually is, isn't it, that you weren't charging premium to Horizon for the war risk policy?
No, we are charging. You have to refer to the debit. I told you, debit note is part of the policy. Altogether, when we issue the policy, there is also debit note along with that one.
That you send
Together.
to Horizon?
Yeah, for arrangement. And for the insurance also we are sending.
Okay, I'm not talking about what you pass on by way of premium or what you charge by way of commission to reinsurers.
For the Horizon.
But between Al Buhaira and Horizon,
Yeah, there is a premium. Yes.
there was a premium notice, an invoice
During the negotiation with the quotation.
during negotiation. But
Yeah.
in the policy schedule itself in 2018, there's no reference to premium, is there, anywhere?
In the policy itself, it's not mentioned, but it is mentioned the debit note. When
Okay.
we send to the Horizon.
Now, we've seen a letter from Clyde & Co., which was written to Horizon in 2021. Have you seen that letter? It's at page 527 of the bundle.
Yes.
Can you look at page 531, paragraph 2.6.1? Can you see there that Clyde & Co., presumably on Al Buhaira's instructions, wrote to Horizon to point out that despite numerous requests and correspondence from Al Buhaira requesting payment throughout the policy's period and subsequently, the assured has failed to pay the premiums due under the policies? Now that was true, that sentence, wasn't it?
Yeah, it's true.
So from 2015 through to 2019, Horizon never paid the premium that it was meant to pay to Al Buhaira.
That is, I can't answer that question because that's related to the finance team. They can give you the proper answer about this.
And isn't the reality that if you were doing your job as an underwriter in 2018 properly, a proper underwriter would have refused to underwrite 2018 if 2015, 2016, 2017 had not been paid?
No, but this is what we can tell you about this one. The premium, it is not my matter. It is the accounts department itself. As technical department, we are just following instruction like from the CEO, whether to proceed for renewal or not. That is the main issue.
The reality is that Mr. Kadumi had made the decision that it didn't really matter whether or not Horizon paid premium between 2015 and 2018. It didn't really matter to the underwriting process at all because Horizon was owned by Mr. Al-Sari.
I don't know.
You don't know. Mr. Al-Sari was the longest standing member of the Board of Directors.
Board of Directors, yes, correct.
And he was chair of both the Audit Committee and the Nomination and Remuneration Committee. So, despite the fact that his company was not paying $1 of premium, Al Buhaira carried on underwriting the risks in any event.
Yes, we carried it since 15 till 18, yes.
And that's,
the policy, no?
and that's because in that period of time, because of his influence and control over the affairs of both Horizon and Al Buhaira basically couldn't care less what the real risk looked like. You would just insure his fleet of vessels come what may.
No, that's not true.
Can I ask you a question? Have you, as an underwriter, ever refused to underwrite a policy because the insured has failed to pay the premiums in previous years?
And some policies, yes, but just depend on the relationship.
So it's all about the relationship?
Yeah.
Okay, thank you.
It's very helpful. But precisely because of the relationship with Horizon and Mr. Al-Sari, Al Buhaira was willing to turn a blind eye to the fact that premium had not been paid in 2015, 2016, 2017, when deciding to underwrite in 2018.
Actually, I can't say it's not a blind eyes. Actually, we cannot say like that one. But as I mentioned to the justice, it's about the relationship. And as you know, we are the technical departments receiving instruction from the higher level.
Precisely. Now, can I ask you then to look, please, at page 442. At 442, at the bottom, can you see that there's an email from Entisar Ateya to Sajesh Babu on the 3rd of June 2019, which was copied in also, I think, to you, Mr. Shalab. Do you see your name
Yes.
there? And she was following up with you to alert your company to the fact that the risk was due for renewal in 7 days' time on the 10th of June, and would like to have your renewal instructions by return. Is that correct?
Which mean addressed by, you are talking about the email sent by Shaju, right?
Sorry, at the very bottom of page 442, Entisar Ateya emailed to Sajesh Babu.
Okay, yeah.
You were copied in as one of the copied
Yes, that's
recipients.
correct, yes.
And can you see that she was asking Sajesh on the 3rd of June to have your instructions about renewal by the 10th of June?
Yes, she asked Babu, Mr. Babu.
Now, when that happened, presumably Mr. Babu, who's in the reinsurance department, came to see you, or Mr. Kadumi, to say, are we renewing the underlying policies or not?
No, the reinsurance department, they are not waiting instruction from Mr. Kadumi. They are waiting from technical department. So they are relying on us when we are sending to them the instruction just to proceed with the renewal.
Can you remember them coming to you or somebody in your department to say, we need some instructions, are you renewing the underlying policies?
Yeah, usually yes, will send us, please provide updates.
Can you remember?
I don't remember exactly what was that time, but what I'm telling you, what is the situation, not only for this, just common for all policies.
So can you see at the top of 442, and you can see the email starts at the bottom of 441, can you see that Mr. Babu responded on the 16th of June 2019, which is 6 days after the renewal date of the 10th of June, and he said in an email he described as urgent, we are pleased to confirm having received firm order to renew the above caption policy for a further period of a year, as per the attached terms and conditions. Our closing of 20%, reinsurance commission will follow soon. Kindly confirm by return to enable us to proceed further. Why was it urgent for Mr. Babu to respond?
Maybe that time there was he sent email to them and there was no reply, just he's following with them, just to confirm their share.
And
Maybe there is another correspondence between those emails. I don't remember.
who would he have spoken to in your department about this firm order to renew?
We are sending instruction to reinsurance department. That's to receive firm order. And
So-
they are the one who will go to inform the reinsurer
So who did you receive the firm order from?
from Horizon,
Yeah, but who at Horizon?
Emelda.
Okay.
Ah.
Now can you see if you look above that at 441, the email says contents noted and we confirm binding the cover for the above mentioned cover for a further year with effect 10th of June, subject to NKORL, which is no known or reported losses up to date. Current listed areas JWLA 024, all other terms and conditions expiry, await review closings accordingly. You were copied into that email. Do you remember seeing it at the time?
Yes, that is the email received by Iman.
And did you ask your client, Horizon, whether there were any known or reported losses up to date as at the 16th of June?
Yeah, we asked him the status if there is during our communication during the renewal.
And what did they say to you?
They get nothing, they said. But we put in the policy itself, subject to no reported loss. It was clearly mentioned there.
That they said nothing in response to your questions.
When we asked if there is, of course, if there is anything, they will inform us. Just reply simply, please proceed for the renewal.
And you, in turn, said nothing to reinsurers about the position in terms of no known or
No,
reported
they already
losses.
sent confirmation, no non-reported loss. We already confirmed that one also.
You
We confirmed that in the policy also, Horizon.
Now, what then seems to have happened is that at page 440, can you see that Aris at the bottom of that Ali Sage FR had to chase Al Buhaira on the 16th of July for the premium closing information. And at the top of page 440, do you agree Mr. Babu wrote back to them to say, please find attached, which were the premium closing documents?
Okay,
Do you agree with that?
I saw that one also.
Okay. And the premium payment is not actually made by way of a wire transfer. It's an accounting exercise, isn't it?
I believe so. This accounts has to confirm this.
And that's because, as between Abnick and Aris, at the end of every financial year, there's a net reconciliation.
That
between-
is financial department.
That's
can
financial.
answer, not us.
But no premium was actually paid by Abnick to Aris on that date.
I don't know. This is the financial department that has to confirm.
Okay. And then what seems to have happened then is that there was a request made at page 450. If you look at page 450, at the bottom of page 451, you'll see an email from Sajesh Babu on the 9th of September 2019. You were copied in on that email as well. And at the top of 452, you'll see reference to above subject account. So far, the insured didn't comply with the PPW under the policy. For this reason, we had to send the insured a notice advising them of cancelling the cover if they didn't comply soonest. Now, do you remember that?
I remember there was some communication, yes.
And isn't the reason, in fact, that you were seeking to cancel the policy is because by this time, Mr. Kadumi knew that there had been an alleged disappearance of the ship, the Beta?
I don't know.
You don't know that?
No, I don't know.
And if you go back a page to 450 and 451, you'll see that Mr. Babu initially asked for the policy to be cancelled with effect from the 1st of September 2019 due to non-payment of premium. Our pro rata refund will follow soon. Kindly mark your records accordingly. And that was done as a matter of courtesy by Aris. But if you look at page 449, do you agree that Mr. Babu then followed up to note that at the bottom of 449 on the 6th of October, due to oversight, we mentioned 1st of September. The cancellation date should read from inception date 10th of June 2019. Can you recall giving him instructions to change the cancellation date from the 1st of September to the 10th of June?
No, it's not about, maybe he missed to mention 10 June. He mentioned maybe 1st September.
So your intention was, your initial was always to cancel it from ab initio?
Yes, usually it's from inception date, because they failed to pay the premium for that policy.
What had changed in the relationship between Horizon and Al Buhaira? What had changed between the 9th of June 2018 and 9th of June 2019 and October 2019? What had changed in the relationship to make you want to void ab initio the underlying policies?
Because this instruction received by our CEO.
So something had changed in the relationship between the CEO
I don't know, no, and I'm not
and
about
Mr.
relationship.
Al-Sari.
I don't know about the relationship, but we are receiving instruction from the CEO to, for example, for example, client is not paying the premium, so we need to cancel the policies. We are receiving instruction from him, of course.
Okay. And then if you look at 447, page 447, can you see that Mr. Al-Sheikh wrote to Mr. Hamama to note that all reinsurers have agreed to cancel the policy from inception. Please do the same, do not make it an issue. Do you know which reinsurers he was referring to there?
I think he's talking about the hull insurance,
Okay, so which ones by name?
the full fleet, full fleet.
The
Hull, there are, I told you, there are so many policies. All policies is cancelled, not only one particular policy. Or insurance means for related to the other policy, hull reinsurance.
so somebody.
Because for our risk only we have one reinsurance ours.
Sure.
So we don't have multiple reinsurance. Yeah? So for other hull insurance, of course, we have multiple reinsurance.
So somebody, was it your team or in the reinsurance department, had to get in contact with all reinsurers on the hull policy to secure all of their agreement to cancelling the policy ab initio?
Yeah, that is the reinsurance department.
Okay.
They will inform all reinsurance. We are going to cancel this policy due to non-payment agreement. That is there, but they are communicating with all reinsurers.
And this was quite a dramatic development, wasn't it?
I don't know. I cannot say anything about it.
So much so that Mr. Al-Sheikh was instructed to ask Mr. Hamama not to make an issue of this, but just to cancel it ab initio.
I believe Mr. Hamama, he was telling why the cancellation from inception, not from the September. This was the argument in that time.
So isn't the reality of the situation that when you agreed to when Al-Buhaira agreed to underwrite the risk in 2015, it was just a question of Mr. Kadumi saying to you, get it done?
Of course, because such account like this, high value, of course we are referring to our CEO for his instruction. Maybe he's not willing to renew. Maybe something we need to get his opinion also.
And so that's why the reality also is that you just simply got it done without asking any particular questions.
What exactly do you mean by particular question with whom? With
Well,
Horizon?
Well, you just didn't do any underwriting, did you?
No, I did my underwriting properly.
Sorry?
I did it properly. We asked all the questions regarding the class, regarding the status, if there is any claim. We have done our part. We received confirmation from Horizon to proceed for renewal. We intimated the CEO. CEO, okay, go ahead.
But there were a ton of red flags, weren't there? There was all of Mr. Al-Sari's involvement with the Sharjah courts. There was the fact that no one had paid any premium for years. And all this discrepancies about the class of the entire fleet. All of those red flags, you just completely ignored all of them, didn't you?
No, because I was not aware about all this, what you are talking about. If he has some issue with Sharjah course or some other,
But-
it's not our matters actually.
But Mr. Al-Sari would have known about all of those issues, wouldn't he?
I don't know. I cannot comment on this.
And Mr. Al-Sari was senior management both of Horizon and senior management of Al-Buhaira.
So what? He is a board member, fine, but he's not involved in any underwriting or any operation. Even he never be covered even the communication with the renewals.
Now, in your witness statement that you gave to Justice French, but which we haven't seen, it seems that you made the following assertion in your evidence. Can I ask you to look at page 885 of the bundle? The position at paragraph 53, as recorded by the judge, was that Mr. Shalab referred to matters which he said had not been disclosed to the claimant at the relevant time, and the extent to which, had they been disclosed, the disclosures would have affected the claimant's decision.
Yeah.
Ultimately, his decision is the officer responsible for making the final recommendation to the general manager to underwrite the policies. And so the reality of the situation is if you personally had known of all these red flags, what you should have done is recommended to Mr. Kadumi not to accept the risk or
Yes.
underwrite the policies.
Correct. Of course, if there is any red flags, of course, if there is anything which is some facts which is we are aware about it, either maybe we can change the cover, okay, or we can maybe send advice to our CEO that these the facts we received. we can give him recommendation either to change the cover or not to proceed with the cover.
And if you see at paragraph 54, what you said to Mr. Justice French was that if you personally
Yeah.
had been aware of the true position with respect to class, you personally wouldn't have agreed to extend cover to the vessel at all under either of the policies.
Yeah.
And you would agree with that, wouldn't you, that the position must be true also of Aris as the reinsurance company, that if Aris had been aware of the true position, it wouldn't have agreed to extend cover with respect to
Yes, I
its
agree.
reinsurance.
Yeah.
So it was both material information to
Yes.
the reinsurer and they were induced by the false information.
Yes, correct.
But in your mind, you take the view that you personally didn't know, and as a result of that, it must necessarily follow that nobody at Aris knew. Is that your position?
Yes.
But what would you say if the evidence showed that other people at Aris did know what the true position was?
Did know about the class, you mean?
If somebody else whose knowledge is to be attributed to...
They will inform us, of course.
No, but let's just say Mr. Al-Sari knew about these matters. Mr. Al-Sari's state of mind
Okay.
can be attributed to Al-Buhaira, can't it?
I don't know whether he was aware or not aware, because not by part, as I inform you. I'm just informed technical part, which is related to my work only.
And if
Now,
you,
whether he was involved, he was in class or no, we don't know.
and if you were running an marine underwriting team in a professional way, you would have picked up on these issues, wouldn't you, before you wrote to Aris with a schedule that told them that a vessel like the Beta was classed the Pura Veritas when it wasn't.
Yes, of course. No, because if we are aware about this information, we will not go to proceed for anyone. I told you, cover will be changed, maybe we will not proceed, maybe so many things will be there. But this information was not disclosed to us. at the time of
Just to be
renewal.
clear, because in a sense I have to put my case and then be quiet.
Okay.
Your department, the underwriting team,
Yeah.
Supervisor Mr. Kadumi, should have known about the true classification status of the vessel, the Beta.
No, we are not, Buhaira has nothing to do with this one. We are not going to see whether the vessel is a class or not class. We are asking the client to provide this information, not us. It's not the Buhaira Abnic practice to search for this information.
It's not your practice when you're dealing with an insured like Horizon, where there's a strong commercial relationship.
I'm not talking about Horizon, I'm talking about general. This is not Abnic, not only related to this. Whatever anything related to class, to updates, because this is the interest for the client himself. He is providing information to us. Based on that information or material facts, we are following. I'm not going to check behind the client whether that is a class or not class. Unless, if there is a claim, then we'll go to search, yes. We'll go to check.
Okay, well, with the benefits of your experience in this case, where you now spent 10 million dirham fighting this claim,
Yeah.
don't you think, with the benefit of hindsight, it would have been helpful if somebody in your team had just checked the IMO numbers, given that Horizon were telling you that the classification, there was a problem, they were in the process of renewing classification?
No, of course, we did our part at the time of a claim. I am personally also contact the class themselves
Okay.
to get information whether the vessel was a class that time or no. And they confirmed to me the phone never a class. After the claim, that was not before, at the time of renewal.
And separately to the classification status, there was this issue about whether the vessel was in layup and whether it was cold stacked in a high risk location. You were aware of that?
Yeah, we were not aware, no.
But it was your case, both in Clyde & Co.'s correspondence and before Justice French, that there had been non-disclosure of those facts.
Yes, correct. There was no disclosure by the insurer whether the vessel was laid up in the Horfakan. Never disclosed that one to us during renewal I'm talking.
So it follows necessarily that there was non-disclosure by Al-Buhaira to Aris about those facts.
No, from Horizon to Al-Buhaira. That's material. But I'm telling you, that is also, we were not aware about those facts
You
at the
weren't-
time of renewal. So, of course, when we inform the insurers, if there is any such things, of course we'll inform them. That's fine. Prior renewal.
Okay, you personally
Yeah.
say you didn't know about the cold stacking of the vessel.
Yeah, I was not aware about it.
but Horizon should have told you what the true position was.
Because this is material facts to the risk.
It's
Yes.
material facts. And in turn, when you place reinsurance with Aris, nobody on the part of Al Buhaira told Aris that the vessel was cold stacked or not trading.
No, nobody
No.
informed. Because at that time there was no information about that, the Khurfakan Ledab or other the class.
Okay. So what I'm suggesting to you is that Al Buhaira, the insurance company as a whole, should have known of those facts, but failed to disclose them to Aris.
Not fail. We did not fail to disclose. No.
But you should have known of them.
We should know, of course, before anyone. This facts is material to the risk, and it has to be disclosed by the client.
Sorry, you're using should have, you're at cross purposes in the use of the word should there. You're saying you should have known, i.e., had you exercised proper diligence, you should have known. He's saying, yes, we should have been told.
Yes,
There's a slight difference in what you're saying.
You're
to
quite
me.
right. I hope I'm not labouring the point.
No, but when you're cross-examining, I mean, obviously English is not your first language, and so we understand. The nuances of his questions sometimes get lost, but I'm following it.
As I understand your position, Horizon, whether it was itself, Miss Amelda, or somebody else at Horizon or the brokers, they should have told you that the vessel was laid up, cold stacked, not trading, and it was in a high risk zone. They should have told you that.
Before anyone, yes.
Before renewal.
Because this is material facts.
Yes. And your position is that it was not your personal practice to double check those facts.
Yeah, it's not our practice. No.
But in fact, you made the same representation, or you didn't disclose the same information to Aris, because Aris were never told by anybody that the vessel was not trading, it was laid up, it was cold stacked in a high risk zone.
How come I need to inform the insurance about something which we don't know?
So the point I'm making to you is that your underwriting department,
Yeah.
I'm trying to make it respectfully, so I'm not trying to be rude, but in 2018, if you were doing a proper professional job of underwriting, you would have checked these facts.
It's not the ABNEC practice to check these facts. This is follows. That's
Just bear with me one moment, my lord. Thank you, Mr. Sharp. Those are my questions.
Thank you very much, Mr. Craig. Thank you. Thank you so much for your time. We appreciate it. You are now free to go, if you wish.
thank you so much.
Thank you. Can we just then take stock as to where we are on the timing?
I would hope to be able to deal with both remaining claimant witnesses this afternoon. I don't think the third factual witness will take as long as the first two. And then Mr. Abdeen, as you know, there's a debate about admissibility, but we're going to deal with it to then it, I think.
Yes. Okay. How does that fit in with the timetable?
Sorry, and that's sort of on the assumption that we're sitting beyond 4 o'clock, possibly up till 5.
Yes. Well, yes. I'm very happy to sit until 5. I just need to know when to take a break for the court reporter and so on. But in terms of you said that. Sorry, I haven't got the timetable at the forefront of my mind. You said that Mr. Potts is meant to have finished all the fact witnesses
By lunchtime, yes.
by lunchtime. So
yes.
we're running late on that basis.
Yes, I mean, my lord's indicated he's prepared to sit until 5 o'clock.
Yes.
We are content to sit until 5 o'clock, but that has to be, in my submission, the absolute guillotine for Mr. Potts and his questions, and that is what it is.
Yeah, I'm not going to keep everybody here and the staff here beyond 5 o'clock.
No.
Okay. Is that okay?
It's fine. I mean, I appreciate.
You know, the absolute guillotine. You're comfortable with that?
Subject to the unforeseen contingencies of,
Okay.
you know, very difficult judicial interventions. I mean, I can't really anticipate what slows me down. But I have tried to get through relevant material with this witness, for which I'm grateful.
My Lord, I should just indicate that our expert, Mr. Abdeen, is based in Abu Dhabi, and so he has come up here today and has made arrangements to be here today. I don't know what his plans are tomorrow. At present, I understand that he certainly isn't expecting to be here tomorrow. So that is another reason why Lenfriend does need to finish today.
Well, I assume Mr. Abdeen is not saying he can't be here tomorrow. Is he?
I haven't yet consulted him about that.
I mean, if there is good reason that he can't be here tomorrow, I'll interpose him.
Yes.
Well, we better find out.
I'd find out.
Your Honor, I prefer, if it's possible, I'm very busy traveling on Thursday. If I can do it today, it would be great. But if it doesn't work, I'm committed to come tomorrow. But my preference would be today.
I understand preference. I would really only alter matters if it wasn't a matter of preference but compulsion. So we'll proceed with the fact witnesses and finish them this evening, and then expert witnesses tomorrow.
Well, no, because the way in which it's been done, on Lenfriend's insistence, is that he has all our evidence goes first.
Oh, we're going to take facts.
Yes.
I see.
So that's why I say he has to finish. So Mr. Potts insisted that Mr. Aberdeen go before his own factual witness, and so we are taking it's the unusual order. So Mr. Potts is doing all of our witnesses.
Yes.
And the timetable provides finish today at 4 o'clock. Obviously,
Yes.
now we're giving an extra hour indulgence to that.
Yes.
And then the timetable is tomorrow. I cross-examine Mr. Hamama,
Okay.
and then the defendant's expert. So that's why the point arises in relation to when Mr. Abdeen is to be here, because
Well, Mr. Abdeen will be cross-examined tomorrow.
today.
Just to be clear, I mean, I hope we can start with Mr. Al-Sheikh now. I hope I can get through him quickly. We get to Mr. Abdeen this afternoon, and I hope I can be done by 5 p.m. But then tomorrow would be my witnesses. But the reason I'm a little bit cagey is because sometimes it takes a bit longer, and I'm trying to pray and aid my own self-inflicted collapse. But yesterday we did finish earlier,
Yes.
with a bit of flexibility built into the timetable. So I'll try and move things quickly, and my aim is to finish today.
Okay. Well, let's just take it under advisement and see where we get to. I'm sure you're both very sensible about it. Right. So the next witness is
Mr. Al-Sheikh.
Mr. Al-Sheikh. Right.
Will you be swearing in on oath? I affirm you. Would you like to swear in with the Quran? Yes. May I proceed, Your Honor? Can you please confirm your name and occupation for the court's record?
محمد عبد اللطيف أبو الشيخ Reinsurance Assistant Manager.
Please repeat after me. I swear by the Almighty God
I swear by Almighty God
that I will say nothing but the truth.
I will say nothing but the truth.
Thank you.
Thank you.
Please do sit down.
Mr. Al-Sheikh, good afternoon.
Good afternoon.
Could I ask you please to be shown the document in the small ring binder in front of you at page 277.
Okay.
You should have a document headed First Witness Statement of Mohammed Abu Al-Sheikh. If you could turn, please, in that document to page 286.
Yes.
You should see a signature.
Yes.
Is that your signature?
Yes.
And is this your witness statement?
Yes.
And do you confirm that its contents are true?
True.
Thank you. There'll be some questions for you.
Hello, Mr. Al-Sheikh. My name is Mr. Potts, and I'm, as you know, the lawyer for Aris. Mr. Al-Sheikh, you've got your statement there in front of you. If I understand it correctly, you studied in Jordan, and your degree was in economics and administrative science.
Yes.
You've never studied law, have you? You're not a qualified lawyer?
No.
Not in any jurisdiction. And in your career initially, you worked for Al Manara Insurance. That was in Jordan, was it?
Yes.
And that was until 2007. You then left insurance and went back into it in 2008 for a company in Jordan, United Insurance Company.
Yes.
And you only joined ABNIC in Sharjah in 2009. Is that correct?
Yes. March 2000.
March 2009. Now, there is in the bundle a structure chart, an organisation chart, and in a sense I apologise to everybody else who's looked at this a few times, but I'm not sure you have. Can I ask you to look, please, at the document which you'll find in the bundle at page 367. Have you seen this document before ever?
No.
Okay, well, you take it from me, it's a document published by Al Buhaira National Insurance Company, which you can see at the top left, 367. And it was describing the organisation of Al Buhaira, I think in 2018 or 2019. Can you see on the first page there's a whole lot of departments described that are all under the board of directors and the managing director and the general manager. If I understand matters correctly, you sit in the reinsurance department, which is on the right of the structure chart. Is that correct?
Yes.
And if we go over the page, a couple of pages to page 369, can you see that in the box for reinsurance on the left, there's Ayed Saleh as AGM. That means, what does that mean? Assistant General Manager? Do you know what that meant? AGM?
AGM, Assistant General Manager, yes.
Okay, and then there's Ala Abi Aishe, Deputy Manager, do you think? Deputy means department or Deputy Manager?
Department Manager.
And then there's your name, is it? Mohammed Al-Sheikh, Senior RI Specialist. That's referring to you.
Yes.
So in that reinsurance team, am I to take it that you were more junior at this point in time to Ala Abi Aishe and Ayed Saleh?
Yes. This was previously, but I have promoted to assistant manager, department manager.
When were you
Assistant department manager.
when were you promoted to that position?
18.
2018. When in 2018?
Exactly, I don't remember.
Was it later in the year, after June, or the beginning of the year?
I don't remember.
You can't remember. Now,
Quite time back.
you can't remember the date of your promotion to this title in 2018. That's was that 7 years ago. So if we then look on the same page, can you see there are different technical departments Life Department, Medical Department, Marine Insurance Department, Fire and GA Insurance Department, Motor Insurance Department. At that time, were you involved in any of those departments?
Reinsurance.
Sorry?
Reinsurance department. That time I used to handle all line of businesses, assisting Mr. Ayed to handle reinsurance related to all line of business.
Could you just speak a little louder?
Okay.
So at the time, you assisted the reinsurance department to try and place reinsurance for all lines of business. Is that right?
Yes.
And are you still dealing with all lines of business today, or do you have a particular focus on some lines rather than others?
I'm specialized for life and medical department, right?
Life and medical.
Yes.
So not marine war risks.
Now, no.
No. Can I ask you to look, please, at your statement at page 283. Can you see at paragraph 4.10 of that statement? You say Abanic's premium closings in the placement document for the 2015 year were issued on or around 8th of June 2015. I cannot recall when the original cover note was received, but when it was received, it was duly signed by Mr. Ayed Salah, Abanic's Assistant General Manager of Reinsurance, and returned to Aris as assistant. How do you know that it was received and returned and signed by Mr. Ayed Salah? How can you recall that?
We have a copy in the file, and I check our major accounts from time to time, so I can't see it.
Okay. You then say the direct policy was then issued, and by that I think what you're talking about is the underlying insurance policy issued by Al Buhaira to Horizon. Is that correct?
Policies are issued by departments, technical departments.
What are you referring to when you say the direct policy?
Underlying policy.
So the underlying war risks policy.
Yes.
Did you have anything to do with the underlying war risk policy?
No.
No. You then say, and it was governed by UAE law.
Yes.
We've heard actually from the head of marine underwriting and claims that that policy was governed by English law in his evidence.
I don't know actually. Underwriting it's by UAE law. Jurisdiction is.
Sorry, could you just keep your voice up, please?
Okay.
So you don't know what the governing law was of the underlying policy. Is that the true position?
I know reinsurance arrangement. What we receive from the underwriting department, we do arrange with reinsurance companies.
Well, I just want to be clear because you've signed this statement of truth. Can you see your statement of truth on page 286?
Yes.
You say the contents of this statement are true knowledge, information, and belief. And when you were just asked to start giving your evidence, you swore your evidence was going to be true. This assertion that the direct policy was governed by UAE law, that is false, isn't it?
Sorry, can you repeat?
What you say at paragraph 4.10, that the direct policy was governed by UAE law, that is false, isn't it?
This is according to my understanding. It was issued according to UAE law.
But who told you that? Who gave you that understanding? You don't tell us.
That our usual practice.
Sorry?
Our usual practice.
Sorry, you're not even in the department that underwrites.
But
How can you know what the usual practice was of the marine underwriting team in 2015?
that's what we receive from underwriting usually.
Have you even looked at the underlying policy? Have you looked at it?
Briefly, yes, I received quotation from underwriting.
So when did you look at it?
At that time, 2015, when we do the reinsurance act.
Can you see in this statement there's a footnote, footnote 9, and there's a reference to MAS 1/2 to 5. Did you actually look at that policy when preparing the statement?
I look at it.
Is that a yes?
I look at it, yes.
So you look at it on the 28th of November 2024?
Yes.
So shall we look at it, please? And there's a copy of it in the bundle.
418.
Sorry?
418.
Thank you, Judge. It's at page 418. Can you look at, please, 418? And it goes through to page 421. Did you have a copy of this in front of you before you signed that statement on the 28th of November 2024?
Yes.
Okay. Where in this document does it make clear that this policy was governed by UAE law?
Jurisdiction, United Arab Emirates.
Well, what about the word cover above it? Institute War and Strikes Clauses, Hull's time dated 1/11/95, CL 281. Have you ever seen that document?
Yes.
Was that document in front of you when you signed your statement on the 28th of November 2024?
You mean the details of Institute's wars and strike?
Well, you can see the word cover. It says Institute War and Strikes Clauses Hulls, time dated 1/11/95, CL 281. Was that document, CL 281, was it before you? Did you read it when you signed your statement?
No.
Can I show it to you, please? It's at page 400. Page 400 of the bundle. Can you see at the top, under the title, it says this insurance is subject to English law and practice.
Okay. Yes, I see.
Doesn't that suggest to you that, in fact, the insurance is subject to English law and practice?
Mainly, jurisdiction is the governor law. UAE, it's the governor law for this agreement. These are clauses which is attached to the policy, attached to agreements. So the main is UAE federal law, and these are, and all these clauses, it's already made by London Market, issued by London Market, so it's normal to be.
So they're all London Market clauses, and then for what it's worth, it also incorporates the document at page 394. Can you see it 394 under the Institute Time clauses? The insurance is subject to English law and practice. Do you agree that this clause 280, CL 280, that's governed by English law and practice?
It's issued by London Market.
It's issued by the London
London
Market, and it includes clearly at the top of the document, it's subject to English law and practice. That's correct, isn't it?
It's written, yes.
And likewise, the Protection, Indemnity, War and Strikes clause, which you find at page 388, do you see at the top that this insurance is subject to English law and practice?
Yes.
Now, if I'm correct in understanding what you've told me earlier, you're not a lawyer in any jurisdiction. That's correct?
I'm not aware. Yeah.
You're not a lawyer practicing in UAE federal law. Is that correct? You're not an English lawyer. Is that correct?
Yes.
And you're not a member of the legal department at Al Buhaira National Insurance Company.
Yes.
So you're not really in any position whatsoever, are you, to express a view as to what is the governing law of the underlying policy?
Legally, no.
No.
But technically, yes.
Sorry, technically yes, but in reality no.
Legally,
Legally no, but technically yes.
we have practice. We follow.
Now, when you were asked in your role as a member of the reinsurance team at the time, whether that was a reinsurance specialist or an assistant general manager or whatever the job title was, you were just being asked to perform an administrative task in terms of reaching out to your contact at Auris with a view to placing war risks reinsurance back to back with the underlying insurance. Isn't that correct?
We receive quotation from the department, and we do reinsurance according to this quotation.
Okay, so can we look, please, at page 406? 406 is a bundle.
Okay.
Can you see an email at 406 which you seem to have sent? Your name is at the bottom of the page just before 405. You sent an email to Ghassan Hamama. Do you know why it was high importance?
It's major account.
It's a major account
We consider it major account.
for Horizon. And that's because Horizon was owned by Mr. Al-Sari?
I don't know.
You don't know. Why is it a major account?
Because it's a huge fleet and facultative business. Usually we do it in high, we need to provide our quotation and cover from reinsurance to our clients as soon as possible because severe competition for many reasons it will have. And this is a major account, big account.
A major account.
Major account.
Now, can you see, you say that you've received a firm order from our client to insure his marine, hull, war and P&I policy for our company. Just pausing there, your use of the word his there is a reference to Mr. Al-Sari, isn't it?
No, our client.
But
Client
wouldn't you
is
say
Horizon.
wouldn't you say its marine, hull, war and P&I policy if you're talking about a corporate client?
We are talking about Horizon here.
Horizon. But what I'm suggesting to you is you're talking about Mr. Al-Sari, which is why you use the word his.
No, at all.
And then you say details of which are as per the attached underwriting information. Legally, you kindly confirm your 100% fact support at highest commission possible. Your urgent response will be highly appreciated. You would have attached to this document a draft version of the policy that was being proposed to be issued to Horizon. We don't seem to have the attachment, but do you agree that the attachment would have looked like the documents at page 418 to 421 of the bundle? A draft version of those?
Okay, these are the underwriting information.
Sorry?
What exactly the question? Sorry, can
Okay. In your email from the 26th of May 2015, you said that you were sending details as per the attached underwriting information. What do you think was the underwriting information attached to that email?
Placement document, which is quotation and list of vessels.
Okay. Would it also have included all of the terms of the proposed cover?
I can't exactly remember, but most likely yes, because we receive all information, underwriting information from department, and we submit it to reinsurance.
So can I ask you to look at pages 418 to 421? What you attached was essentially a draft version of this set of documents. It was a draft copy of the whole policy with all these details, the policy number, the name of the insured, the vessel, as per the schedule attached, interest. You see the schedules that are then referred to: built, GRT, type, class, flag, sum insured, period of insurance, trading area. And then at page 419, we just looked at, I think, cover, institute war and strikes clauses. And then under jurisdiction, United Arab Emirates, all these clauses and conditions. And if you go over the page, please, to 420, there's some more conditions there. And then at 421, there was a schedule. And you can see, if you look at the schedule, that there was some information about the sum insured and so forth. Is that essentially what you would have sent, except it wouldn't have been the signed version, just a draft version?
You mean the signed one? This is the one which we have sent?
No.
What do you mean?
To that email of the 26th of May, you sent a draft version of this, which you had received from the Marine
From the
Underwriting
underwriting,
Team.
yes.
Marine Underwriting Team sent it to you, and they say, can you please send it to Aris to get their approval?
Yes, that is the procedure we follow.
And then if we look at the next email at page 405, so coming back a page, can you see your next email to Mr. Hamama? You said reference are below email. Please ignore the previous schedule and consider the attached one. Only some amendments on paragraph 9. And then you introduce some wording. This policy also to cover the liability of the assured crew of the above vessels which arise from war and strikes and civil commotions risks as per Institute Clause 11195 CL 281 for a limit of liability per capita annual aggregate as per schedule attached. Now just pausing there, who asked you to send that email?
Underwriting department.
The underwriting department. The underwriting department must have realised that the first version of the schedule needed to be corrected to have this language introduced.
Yes, they decide underwriting, and we follow, and we arrange with reinsurance.
Now, if you go back to the 2015 insurance policy document that we just looked at, please, page 419. Can you see at the bottom of 419, although there are no numbers in these different clauses, if you do count them in your head, and you start with the words immediately below subject to, the 9th one is the words, this policy also to cover the liabilities of the assured to crew of the above vessels and so forth. So do you agree that that is precisely the same wording as the wording that you extracted into your email?
I read it again, sorry.
Do you agree that that clause, that 9th clause, is the same as clause 9, paragraph 9, that you refer to in the email at page 405? So it looks likely that the underwriting department had sent you the underlying policy in draft and then with a correction to include that specific clause which you referenced in your email.
Yes.
Now, nobody in the underwriting department ever suggested to you that you should ask ARIS to agree that the reinsurance should be governed by UAE law, did they?
This is our usual practice. We don't specifically discuss it.
It's not your usual practice. Your usual practice, the ordinary practice between Al Bahar and Arab War Risks, is to insure and reinsure back to back on English law governing law.
We never discussed this with ours. We never talk about it in any.
You never discussed it.
We never talk about it.
You yourself, in your position of a reinsurance clerk or assistant general manager, it's not your role to even discuss this with ARIS, was it?
I'm responsible on day-to-day reinsurance negotiation in facultative, even with ours, and also I come back to our management if needed. But this is my understanding. It's UAE law. That's why we don't discuss it, and no one raised it.
Can I ask you this? Do you have authority to negotiate the governing law of the reinsurance contracts that you negotiate?
No.
Thank you.
And you know that Al Buhaira is one of about 190 or 200 members of the ARIS Syndicate, don't you?
I don't know the number, but we are.
And as a result of that, ARIS, which is a specialised war risk reinsurer,
Yes.
it sends technical updates periodically to inform your company of updates to London market wordings, doesn't it?
Suppose.
You
Yes.
suppose?
Yes. I saw some email, some update email from ours, but I don't know some of them about what exactly.
Mr. Potts, I mean, given the shortness of time, I'm
Yeah.
not sure this is an extremely
Okay,
profitable use.
I'm grateful for that indication. The position is, Mr. Al-Sheikh, is that your witness statement has been prepared in collaboration with other members of Al Buhaira's team, hasn't it?
I didn't get the question.
You've been asked to give this evidence
Yes.
to help Al Buhaira's case.
To help.
To help Al Buhaira, you've been asked to say what you're
I've
saying
been
in a
asked
witness statement.
to do a statement, yes.
To do a statement to help them.
I didn't get the word help.
You don't understand me? Or...
Yeah.
Okay.
But I will decide the terms of the contract.
Okay, I'm grateful for that indication. Put it this way. Paragraphs 4. Sorry. I've got the right statement I'm looking at now. Can I ask you just to look, please, at page 281. At 281, can you see at paragraph E, you've said, after ARIS has agreed to provide 100% facultative reinsurance support and confirmation that cover's been bound has been received, ABNIC will issue the corresponding direct policy on back-to-back terms to the underlying insured. Is that correct?
Yes.
So on that basis, once you've received ARIS's confirmation on its reinsurance cover note, that's the end of the negotiation over terms. Because at that point, AVNIC issues its policy to the insured that matches, so far as possible, back to back the reinsurance.
Yes, after our risk confirmation, we give our instruction to department to issue the policy that we get the confirmation from the reinsurance.
So at that point, whatever premium closing information is sent by the accounts department 2 weeks later, that's not part of the terms and conditions, is it? Because Aris hasn't agreed to that.
It's all this bundle. We send on annually, and we're supposed to get it signed by ours also, but we all consider it part of the agreement.
So, for example, the document at page 423, what you just said about anything needing to be stamped and signed and returned, you send out these placement documents with the credit note and so forth, and rather optimistically you ask Al Buhaira, kindly return a copy hereof duly stamped and signed in token of your acceptance for our records. The position is that if they don't stamp it and sign it, then they're not accepting this term, are they?
We consider it that they have received and agreed, because they never rejected or object on this.
And it's true, isn't it, in August 2021, Sajesh Babu was instructed to call up Aris to ask them to sign one of these and backdate it and return it. They refused to do so. Have you read Mr. Hamama's witness statement in this proceeding?
I don't remember this one.
Well, because you know, your department knows, you've never received those placement documents signed and returned, and because you know, therefore, that they're not contractually binding documents, in August 2021, Sajesh Babu contacted Aris to ask them to agree to sign the 2018 placement document, backdate it, and return it to Al Buhaira, which they refused to do.
I don't remember this.
You don't remember that? Now, can I go back to your statement quickly, please, to page 281. Can you see at subparagraph F, you say, when it comes to renewals, the established practice for the cover note issued in the first year to simply be renewed on expiring terms, i.e. on the basis of the expiring terms of the applicable cover note. Now, that's correct, isn't it?
Yes.
It's not to renew on the basis of terms contained in a placement document, is it?
Sorry.
You refer there specifically to expiring terms of the cover note.
Yes.
You're not talking about the placement document there, are you?
As I mentioned before, we consider all these documents, placement documents, are part of the agreement. Whatever it's expired, we renew as expiring basis.
Now, can you see then the next bit, subparagraph F? It's only if material changes the terms, conditions, or limits of cover are requested by the underlying insured that a new cover note or an addendum might be issued to reflect these if necessary, and if specifically agreed between AVNIC and Aris. Now, the insured, Horizon, never asked for the underlying policy to be changed from UAE law to English law, did they?
We never talked about law.
No.
We never negotiated that.
So, if you look very quickly, please, at page 488 of the bundle. Can you see the hull war policy schedule for 2018 there, please? And then just look at page 490. You see at page 490 that it says the contract shall be governed by English law. Do you see that? That didn't represent any change to the existing position under the 2015 policy, did it? It didn't reflect any change, did it?
That is the policy document.
Precisely. So if there had been a material change according to your evidence, it would have had to have been requested by the underlying insured, specifically negotiated and agreed, and then notified to ARIS for ARIS to agree.
But that's between us and the client, not between.
We
We have already agreements with ours.
Okay, but if you look back at page 281, subparagraph F, it's only if material changes of terms, conditions, or limits of cover are requested by the underlying insured that a new cover note or addendum might be issued to reflect these if necessary, and if specifically agreed between AMNIC and ARIS. So because your job each year is to get back-to-back terms, if the insured wants a change to the terms, which might have an impact on the cover note, your job is to notify reinsurers first, ARIS, secure their agreement to the change, and it's only if they agree to the change that you then go back to the underwriting team and say, yes, they agree to the change, you agree to the change, because that way you get back-to-back cover. What I'm suggesting to you is that you never went to ARIS at any point to suggest to them that the governing law had been changed at anybody's request from UAE law to English law.
As I mentioned before, this between that is department manager underwriting, they discuss with the client and they agree something. But we and ours, we have, and we never, underwriter never asked us to change this with ours. So I did not back to ours to ask them to change or to discuss this point, because this between our clients and
Okay.
not between the reinsurance and everything.
Are you familiar with the placement documents that get sent out and the wording on them? Can I ask you to look at the one at page 498? Can you see in your document, dated the 28th of June 2018, that the reference to this phrase, warranted all terms and conditions as per original policy? Now, does that mean that you're telling ARIS that you are warranting to them that they will get the benefit of all the terms and conditions of the original policy, i.e. the underlying policy?
Could you repeat the question?
What's your understanding of the phrase, warranted all terms and conditions as per original policy?
this is follow the fortune clause.
No, hang on. What is your understanding of the words warranted, all terms and conditions as per original policy?
And whatever discussed with the client related to extensions, claims, settlement, so they have to, it's warranty from ABNIC, from ours to us to follow.
Sorry, how are ARIS warranting anything to you in a document produced by Al Buhaira National Insurance Company, which they've not stamped or signed or returned to you?
We send every year, they never reject it.
But this is your warranty to them, all terms and conditions as per original policy.
Yes.
Yes. Now, if we look at your statement, please, we go to page 284. Under the heading Indemnity and Costs, paragraph 6, you see at 6.1, you said, I note there are no claims control provisions in the cover note, none were ever requested, and the placement document contains follow language, which was presented in each renewal and never rejected by ARIS, which provides a relevant part. Now, did you choose to put this quotation in your witness statement, or did somebody draft it for you?
Could you ask again?
Did you choose to put this quotation in your witness statement, or did somebody draft it for you?
But it's the warranty, the same one which we put in our document.
Well, would you note, would you agree that the quotation you have does not fully quote that whole paragraph? It doesn't include the words warranted, all terms and conditions as per original policy, does it?
Well, this is the main part which
So what I'm
emphasize.
What I'm asking is, did you choose just to put that part in, or did somebody draft this for you and suggest to you that you should just only include reference to this bit?
Yeah, of course, it's my statement.
It's your statement, so you drafted it, did you?
No, but of course I got help from our team and legal team, but it is my true statement.
Okay, but you got help from somebody else in the ABNIC team.
How it was presented to court, of course. I did not draft it and write it. Of course, the technical information, it's my true statement.
So can I just ask you, there's a typographical mistake, even in this quotation. You say the fact that reinsurers shall also follow in every respect all settlements agreement between the ceding company and the insured. Would you agree that actually the quotation from the placement document should read all settlements agreed? If you look back at page 498 and compare the two, your quotation is not correct, is it?
We can see the drop the typo.
Can I be 100% clear? There has never been any settlement, has there, between Al Buhaira and Horizon?
We have experience on another claims with ours. Is that the question?
No. You do understand that Horizon and Al Buhaira International Shipping Inc. have been making a claim to do with the Beta, the missing Beta vessel. You understand that?
Oh, yeah, of course.
Of course. And not only has that claim not been settled, that claim has been dismissed by Mr. Justice French by avoiding both the war policy and the hull policy.
Mm-hmm.
So as far as you're aware, there's never been any settlement between Al Buhaira and Horizon.
I don't know actually. No, but according to my understanding, and I remember there is no settlement for this loss, but other losses we are talking about it missing.
For the Beta, there's been no settlement.
Yeah, no settlement.
So there's nothing, there's no settlement for ARIS to follow, is there?
horizon, but we have cost, claim cost, of course.
You have a costs claim.
Of course, claim.
Just on your paragraph 6.2, were you directly involved in the payment made with respect to the Bin Hendi claim? Were you directly involved with that?
Yes.
And your understanding, isn't it, that the Bin Hendi vessel that was lost was a fishing vessel?
No, it's a pleasure yacht.
A pleasure yacht?
Pleasure yacht.
It was a low value vessel, wasn't it?
Almost
$500,000 dirham or dollars?
I don't remember exactly, but it's not also a small amount.
And it was part of a treaty, it wasn't part of a facultative placement?
No, it's 100% facultative.
No, it was part of a treaty, wasn't it?
No, I remember it was fact. It was on fact basis.
Well, I'm going to suggest to you that's wrong. It was part of a treaty because there's a treaty in place with respect to low-value vessels. That's completely different to a facultative placement for a fleet worth $400 million.
I don't remember, but it's reinsured 100% by ours.
And in that case, it was actually covered by war risks because the vessel strayed into Iranian waters and it was seized by the Iranian Navy, and in fact the pilot and his son were captured by the Iranian Navy. Do you remember that? So because the claim was covered, Aris paid the claim under the treaty.
I'm not sure how any of that helps me.
Maybe I could just finish this line of questioning and then stop. But the payment that was made with respect to the loss adjusting fees, that was just an ex gratia payment because the fees were very modest. Isn't that the case?
For this claim?
For Bin Hendi?
No ex gratia payment on this claim. We have informed ours about the loss, and they suggested to assign Richard Hogg, and he confirmed that we have to pay the claim, and they have the cost, including the claim.
But there was no legal
discussion.
liability on the part of Aris to pay those loss adjusting fees, was there?
Sorry.
But there wasn't a legal liability to pay them. They made an ex gratia contribution towards them. They're a very modest sum.
It's Richard Hogg cost, it's claim cost, no ex gratia, no legal.
Well, how much were they, those Richard Hogg Lindley claim costs, the adjustment costs?
I can't remember exactly how much amount, exactly.
Okay. Thank you very much. I've got no further questions for you.
No re-examination.
Thank you very much indeed. That's it. You're free to go. That's quite good timing. We'll take a 10-minute break now. So we'll come back we'll come back at 10. We'll come back at 10:02 actually. Thank you.
All rise.
Well, good afternoon again. Before we start with the expert witness, there's one point which I wish to bring to your attention, which is that yesterday, as I said, we lodged an application to lift the stay in the courts of Sharjah in order to have the proceedings dismissed. When we did so, we discovered that on the 31st of March, Horizon itself had issued an application to lift the stay in order for it to be able to continue with the claim, and that both applications have been listed to be heard on the 30th of April. Now we have the original Arabic versions as well as official translations of those documents, which I was intending to hand up to Harold just so that you can actually see them. They are public documents in the proceedings in Sharjah.
Okay.
And in particular, obviously, the fact that Horizon itself is engaging with the proceedings in Sharjah, seeking to lift the stay and expressly continue with its claim.
My lord, all I can say is we object to this being put before the court, mainly because I only got handed this 5 minutes ago. I finished cross-examining the claimant's fact witnesses. There is no witness who speaks to these documents, and it's highly prejudicial to introduce this in this manner at this stage of the case.
But it's a public document.
Well, be that as it may,
I mean, I come across this point before. They do prove themselves in this court.
we can then make submissions on this by way of closing argument, but can you just note my reservation of rights?
Yeah, I could certainly note your reservations about it and understand that it's come out of the blue, as it were.
Well, and there'll be submissions that I certainly will have to make on these documents if they're going to be looked at, even de bene essay.
Yes.
And some of those submissions will deal with admissibility and the fact that I've been prejudiced in my ability to cross-examine the witnesses, apparently on a contrived basis. So,
Well, I'm not going to anticipate anything if those are the submissions you want to make, and equally, I don't know whether the claimant will be applying for an anti-suit injunction against Horizon. That might also.
Precisely. I mean, but anyway, you've heard me on that as they're handed up, and we'll
Yes, I note your position.
Well, without more ado, may I now call Mr. Dean?
Will you be swearing on oath by affirming an oath with the Quran?
Yes.
May I proceed?
Yes, of course.
Can you please confirm your name and occupation for the court's record?
My name is Osama Abdurrahman Fabdin. I'm the CEO of Abu Dhabi National Takaful. What's the other? Of an insurance company, Abu Dhabi National Takaful.
Thank you. Please repeat after me. I swear by the Almighty God
I swear by the Almighty God
that I will say nothing
that I will say nothing
but the truth.
but the truth.
Thank you.
Mr. Abgin, good afternoon.
Good afternoon.
Hopefully you have a hard copy bundle in front of you, and hopefully it has a page in it which at the top right hand corner reads 303,
Yes.
and you should therefore have what's headed the expert report over Sama Abdeen. If you turn in it to page 316,
Yeah,
you should see a signature.
it is nice.
That's your signature. And is this your expert report?
Absolutely.
And do you confirm that it represents your true and complete professional opinion?
It does. Yes.
Then, same bundle, turn please to page 339.
300. Yes.
And you should have another document headed Expert Report over Sama Abdeen, yes?
Yes.
This done dated 28th of February 2025. And if you turn to page 345, you will see a signature.
Yes.
Again, is that your signature?
It is my signature.
And is this your expert report?
It is my expert.
And you confirm that it represents your true and complete professional opinion?
I confirm.
And then additionally, if I could ask you please to turn in the bundle to page, this may not be in that particular bundle, 921
On the screen? Okay.
on the screen, yes.
Okay, sure. Yes.
And you see a document headed Osama Abdeen's response to the defendant's request for further information, yes?
Yes.
And if you turn in it again to page 925, you should see a signature.
It is my signature.
And is this your response?
It is my response.
And do you confirm that its contents represent your true and complete professional opinion?
I do confirm.
Thank you very much.
Thank you.
Good afternoon, Mr. Abdeen.
Good afternoon.
My name is Mr. Potts, and I'll ask you some questions, if I may.
Sure, please.
Mr. Abdeen, if I understand your reports correctly, you are currently the CEO of Abu Dhabi National Takaful PSC. Now, that is a takaful provider.
It is indeed.
It does not provide what I may describe with respect as commercial insurance of the sort governed by English law.
Let me, if I may, it needs a little bit of explanation. Takaful is a form of insurance, but which observes Sharia. In technical terms, it is the same like insurance. In fact, there was a Takaful syndicate opened at Lloyd's. Also, so Takaful, the only difference in Takaful is the structure of the ownership, where you have in conventional straight line, while in Takaful you have policyholders fund and shareholders fund, but it does get combined. For Abu Dhabi National Takaful, just to give you an example, we do write aviation on direct and fact basis worldwide, excluding USA and Canada. We do write energy worldwide on fact and direct, excluding USA and Canada as a territory limit. We write in the whole region for the other lines of business like specialty lines, property, and all of this. In my time at AIG, American International Group, which I led and established in the region, I did open AIG Takaful in Bahrain. So yes, so Takaful really is a form of insurance. However, the ownership structure has varies. The technical aspects remain as insurance.
Okay. I bought a book on Islamic finance, so I've read a bit about takaful, but in summary, one of the key features of takaful is it is governed by and complies with Sharia law. Is that correct?
It has to be in line with Sharia law, yes.
So it is clearly not a form of insurance that is governed by English law, is it?
Like, if I may say again, that's a question to be answered, but I can quote for you that there was a Takaful syndicate open at Lloyd's, so it must have complied with the requirement of the English law. I'm not an expert in that, but I can confirm to you there is also a Takaful Waqf, which was opened in UK at one point of time, which must, in my opinion, it should have complied with the applicable laws. So it is considered as an insurance, a form of insurance. In the region, in other parts of the world, it does exist as a form of Islamic solution for insurance. So that's my answer, but I don't know UK 100. I was not involved in the syndicate at Lloyd's, but I do know about it because it was offered to us to participate in it.
Sure. Maybe I need to be clearer, so I apologise.
No,
But
it's fine.
the actual takaful contract between the protection buyer and the protection giver, the takaful company, that takaful product is governed by Sharia law.
It is governed by the contract of insurance, and I can share with you the difference. The only difference is the preamble of the policy, where it discloses that there is a policyholder fund, and there is a shareholders fund, and there is a wakala fees. The other terms and conditions are the same like any insurance company. And that's why Abu Dhabi National Takaful, AIG Takaful at that time, was able to offer to a variety of customers worldwide. I mean, as I speak now, we have aviation accounts from UK, Europe, Latin areas, and they are all in line with the terms and conditions of the contract.
I'm not really asking you about regulatory compliance.
No, about the terms and conditions.
So, for example, I have no difficulty with a Lloyd's syndicate being a takaful
Yeah.
syndicate,
Sure.
but it's actually a different legal concept, takaful, to insurance. It may achieve commercially something similar, but it's actually respecting principles of Sharia law, isn't it?
If you allow me, Your Justice, yes. The difference is in the setup of the takaful company, and if the court has time, I can explain. In the terms and conditions survey, technical underwriting aspects is the same. Exclusions, provisions, and that's why takaful companies do participate in business worldwide. Where it differs, where is they have a separate two accounts. They call it policyholders account, shareholders account. What does that mean? The shareholders, they operate on behalf of the policyholders, and that's why it has no difference from insurance. They operate on behalf of the policyholders. If the underwriting fund or policyholders fund make money, they give back rebate. They call it surplus. If it has a deficit, by law, the shareholders has to fill in that deficit by a form of good loan. What good loan means? It has no interest, it has a full commitment. And the company is liable for that. So for the customer, for a client, insured, reinsured, it has no difference. He gets the same coverage. Also, he might get the advantage if there's a surplus of that fund, he can get some rebate. Other than that, everything is insurance. That's why in UK, in Jordan, in Europe, takaful has been accepted and recognized, and that's why I was leading for the region, Middle East and South Asia, American International Group, and we opened a takaful company because it has full compliance with all these aspects.
So just to summarize then,
Please do.
that there are some commercial similarities between takaful and English insurance, for the sake of argument, but one key difference is that these are Sharia compliant contracts in a Sharia compliant structure, whereas, for example, AIG in the US or AXA XL in Bermuda, they will be structured under American or Bermudian or English principles of corporate law, and they'll be issuing policies that are governed by New York law or English law or Bermuda law. Those will be not Sharia law products. They will not be Sharia law compliant, will they?
I think a misconception here, try to clarify again. As a contract of insurance, what the takaful company issues is really in line with the jurisdictions, the applicable laws, if the company choose to do so, because there is no contradiction between those contracts and the Sharia law, because these are commercial, technical, risk taker. If there is an unexpected event, unanticipated, it is covered, all of this. Where the difference comes does not impact the policyholders or the reinsureds. Why? It's in the structure of the framework of the company, where they separate two accounts, policyholders' accounts and shareholders' accounts, and they are combined in front of the authority in terms of liability, because the takaful company is liable up to the last equity of the total company. So that's why we are able to, let me just give you maybe a little example. If my support on aviation is not acceptable to a company based in Italy, for example, they will say your contract is contravening. They will not accept my support. I will not be able to do business. So that's a practical and actual proof. Yes, takaful is one of the forms of insurance, which in my mind, I don't want to elaborate a lot. If you recall mutual funds, mutual companies back in there, there is only no callback, but it's very similar to mutual setups, which are still prevailing in UK, in Europe, and in other parts of the world.
Can I just ask you this?
Yes.
So the structure is in order that there is a sharing between the policyholder and the shareholders, isn't it? The concept is that they're, as it were, in business together within the company to be Sharia compliant.
Your Justice is absolutely right, but in a form of as if the policyholders have hired.
Yes, but
The kafir operator.
within that business, though, the insuring side as opposed to the policy side, the insurer side, the shareholder side, indemnifies the other partner, which is the policy.
In the event of a deficit.
In the event of a deficit. So that makes it Sharia compliant. But so that is the structure of the company, you say, like a mutual company. But can that structure itself issue of policy subject to, for example, London market provisions?
Absolutely, yes. Like takaful companies, there are London or UK has a long history of insurance where insurance started. So what we say in Arabic, it's the Mecca of insurance.
Okay.
So it has a lot of authority. So many of the LM7 wording, institute clauses, API in the past, they were really originated from London, and they are used by takaful companies because there is no contradiction. The only thing you attach to it is a preamble informing the insured that you might be entitled for a surplus if that fund of the pool of policyholders make money. But in terms of coverage, in terms of exceptions, provisions, everything the same. Otherwise, we will not be able to do business except for those who want 100% Sharia compliant, but we do business worldwide.
And so when a takaful structure issues a policy in accordance with London market wording, and they go to reinsurers, so how does that work?
To share with you your justice, most of our reinsurers are conventional.
Yes.
Because takaful reinsurers is not well established, so they don't have enough capacity, and they do accept. They cover it. It's the same because for them, nothing changes. We see the risks, we see the premium in return, and there are terms and conditions they follow. Like
So you would go to Lloyd's, or you would go to Swiss Re or Munich?
Absolutely. Like all my treaty leaders on aviation are based in London and Europe.
Yeah.
All of them are European. I had SCORE leading my treaty, SCORE in Paris. There is no contradiction. They do look at small aspects to comply, but nothing in providing reinsurance support to you. Likewise, if I don't give treaty support, of course, as a company, I'm not that size. I give facultative support.
Yes.
In certain lines of business. I give it to conventional companies. Conventional and takaful, same, because it has no change.
Okay.
I don't know if I...
Sorry to...
No, not sure I'll be able to make 5 p.m., but we've got lots of interesting material there. Just to clarify one point the judge asked you, when you issue the takaful policy, which may be subject to London market wordings, is that policy then subject to English law? Or is it subject to Sharia law? Or is it subject to the law of some other Middle Eastern or Arab jurisdiction?
It could be subject to any of what you mentioned, but if I am not a legal person, I share with you experience and practice. Takaful and non-takaful companies in the region are heavily reinsured because it's an energy, oil producing company, very active. Particularly the UAE is the largest insurance market in the Arab world, which has a hub of many foreign entities, foreign insurers. Just share with you some information might be helpful. Like Marsh, McLennan, they have almost $1.5 billion for their operation handling out of the IFC. Aon between mainland and the IFC, they can come to $1 billion. It's a heavily sophisticated market which seeks reinsurance. You could go at any jurisdiction you want or any applicable law. That's correct. There is no restrictions. However, to have the ecosystem correct, normally when you offer FAC, you offer it to the jurisdiction where the risk is located. And that offer might come from me, from companies within the Middle East market, or from Europe or UK. So let's say one of the companies of ILOU wants to support me. I will tell them the jurisdiction, because I want to have, the world is full of different courts, different competencies. So the system which I was part of creating in this region is to have a match between the reinsurance and the insured. And that's how we do that. But there is nothing to prevent you, whether it's a kafil company or a conventional company, to accept any jurisdiction or applicable law. It's subject to discussion, negotiations. But the trend and the practice in our region to make sure that there is sustainability and credibility of reinsurers, because if I play in my own yard, you play in your own yard, there is a mismatch. So this will affect the effectiveness of insurance and reinsurance, which will affect the umbrella. So the adopted practice is to have it jurisdiction where the risk is located. And they mean by jurisdiction, which is, I know, I don't want to, it's not an legal interpretation, the competent court, which will decide, because I can interpret, you can interpret. Finally, the competent court, what they decide is the final. So just, I'm talking about practice because I was part of that practice, whether with AIG or with my current.
Okay, well, that's a lot of material there, but let me just try and come back with some more preliminary questions, if I may. In your role as the Abu Dhabi National Takaful CEO, you've been in that position since 2010, is that correct?
Correct, where I left AIG, yes.
And between 2010 and today's date, you haven't been in charge of the daily or monthly or annual insurance underwriting or renewal process. You leave that to the underwriters.
Yes, I delegate authority, but you know, the system we have, the board delegates authority to the CEO. The CEO delegates authority to the various departments. There are certain limits. It has to be approved by me. Many things. It's a teamwork, but I'm the type of hands-on because I have a very technical background. I've been an underwriter at the regional level. My style of work, I am with the team. So I am involved in multi-distribution channels and many things. But yes, there is a level of authorities. Comes delegate from the board to me, and there are certain authorities which could go to the board.
Okay, and then on the claims side as well, on claims handling, so inward claims from policyholders to Abu Dhabi National Takaful, you will have a claims team who do the claims
Absolutely.
handling.
Professional claims team, yes.
And when it comes to reinsurance recoveries, do you have another team that gets involved in the process of making reinsurance claims? Yes?
To answer, yes, we have departments which work is distributed accordingly. If you want to make a cash call from your reinsurer, the reinsurer department will inform. They work in hand with the claims. If the amount up to a certain limit, I have to approve it. And there are people, my deputy, and there is a matrix of approval. That all in place. Yes, absolutely.
And in terms of the reinsurance placement, in terms of buying reinsurance, you have another team who are involved in buying the reinsurance. Is that correct?
Correct. What I've done it in coordination with the relevant department. So the head of reinsurance, and in certain cases I have to approve the requests made by that as to the security of the panel of reinsurers. It has to be aerated. Certain aspects, not to have, as to the amount, liability, we have to measure that because you cannot put all your eggs in one basket. So we have like, I've created a manual which was approved by the board to organize, you know, reinsurance is a very risky business if you don't have the right protection. So I have created a manual to organize all these aspects and beyond, of course. There are more details.
Can I just ask then, do you at Abu Dhabi National Takaful issue any marine hull takaful policies?
We do have, as Abu Dhabi National Takaful, we do have, as we speak, yachts, marine cargo, we issue directly. We do not offer reinsurance support in marine business, as we speak.
So you don't provide any reinsurance support?
We have, no, we don't provide reinsurance in the marine line of business.
Okay.
We do, as I said in my statement, in many other lines, but marine we don't offer FAC RI support.
And in the marine business, am I right in thinking that it's lower value yachts? You're not dealing with large, expensive tankers or commercial vessels of that
We
sort?
do have, normally we do have vessels financed by banks. We do insure, we do have a sizable business, but you are absolutely right, it's not the strongest department within our company. It is not.
And what about, in addition to the hull and machinery policy in the marine space, do you get involved in providing war risks cover?
We are, as a reinsurer.
No, as a takaful, primary takaful
If
provider.
we get, it's not a market for us to target much, but if we get it, we seek full reinsurance support.
Okay.
Like we could use ORIS or go to one of the wholesale brokers to find us coverage from other markets or from the local market. They offer, UAE market has some companies which offer war risk on FAC RI basis, but it's not a huge market. Like big companies do have some facilities like Emirates, Adnic, Sukoon. They can offer you some reinsurance, but it's not 100%, big capacity on FAC RI basis.
But just on the war risks reinsurance side, you mentioned ARIS. The position is that Abu Dhabi National Takaful PSC is actually a member of the ARIS Syndicate, aren't you?
We are.
And you have placed treaty business with ARIS in the past?
Not in my time. We don't. I don't have.
Any facultative business?
Once, twice. We don't use ORIS that much, to be honest with you. No.
Okay.
We don't have an obligation to use ORIS or any other company. It's the choice of the company. So wherever it makes commercial merits for us, we will go for it. We don't have any obligatory sessions in our region or any of this sort. We follow commercial, what is our interest, what is our comfort.
Okay, so
I do not recall in the last 5 to 6 years or even 10 years that I have placed business with ORIS. I do not recall.
Okay, but you're a member of the syndicate.
I am a member. We're supporting this initiative. It had its ups and downs. Some companies pulled out. That's all history, not relevant to this court, but yeah.
This may not have occurred to you, and it may not be the only point to be made. But you remember when you wrote your report, if you look at page 315.
If I may. Okay.
Page 315 of the bundle. So it's paragraph 5.1, which is your expert's declaration.
Yeah, please. Okay, which part of it?
Paragraph C, you explained that you know of no conflict of interest of any kind other than any which I've disclosed in my report?
I'm absolutely, if I had any conflict of interest, I would not.
Did you not consider that the fact that Abu Dhabi National Takaful PSC is a member of the Aris Syndicate might not give rise to a potential conflict of interest?
I honestly don't see any merits or any justification to believe so. I mean, it's an event related to a missing vessel between two companies. I have no share, no interest, no even prior knowledge of that relation. So why should I have a conflict? I mean,
If there's a conflict, it's against his interest.
Well, the reason I'm going to suggest that it creates a conflict for you and the company is because it would be convenient for your company to establish some form of precedent that reinsurers are obliged to pay legal costs of a primary insurer in all cases, whatever the merits.
But it would affect him in his pocket as a member of the syndicate.
Well, I'm not sure.
It was a finding against the syndicate. So, if anything, that means that the conflict of interest is against his own interest.
Well, we'll have to make submissions about that, my lord.
Yes.
But, so your position, you didn't think there was any conflict from that?
Honestly, I could never see that coming. I didn't foresee it. I mean, definitely, no. And again, precedents in the UAE or in the legal structures in the countries of the Arab world is not binding, i.e., you could have a court judgment, a Dubai court making a judgment, maybe after 1 year, 2 years, another judge can make a different judgment.
It's one of the joys of practicing law in this region. Yes.
Sorry?
Sorry, that was just a facetious remark.
Yeah. It doesn't, I mean, it will not give a precedence. If that's what you meant, I'm trying to create with this conspiracy theory a precedence. No,
don't worry, I haven't suggested a conspiracy theory on this.
Yeah, no, I'm just joking.
But
okay.
I think technically judgments of courts such as the DIFC would have precedential value relative to judicial courts.
I'm aware. Yeah.
I'm not sure about that.
I mean, it's not particularly English laws 100%, but it's as similarities.
But can I ask you this then? Would you accept that you yourself have never worked as a marine war risks reinsurer?
Personally,
yes.
I have not worked as, I've never been an underwriter or marine risk. Absolutely correct.
And you've never sat in the shoes of a reinsurer reinsuring marine war risks?
Well, I used to run, I'm in 30 years in not senior position, leading positions. I used to lead AIG. And you know, in Iraq, all of these, we were offering out of UAE a lot of war-related coverages but I was not the underwriter for that, but I'm overall responsible for the operations. That's an honest answer in reality.
Now, in terms of your opinion, as I understand it, what you were asked to do by ABNIC, if we look at page 305, just so we sort of understand. Sorry, page 305.
Okay.
Page 305 of the bundle. Do you see at paragraph 1.2, you state that specifically, I have been asked to give my opinion on whether or not there is a custom or market practice that reinsurers shall pay the reasonable cost of insurers in bringing against or defending proceedings brought by an underlying insured in the UAE and the Middle East. So that was the question you were asked to give an opinion on, is that right?
Absolutely, yes. I was approached and I was asked if I can give an expert opinion on this topic. Yes.
Now were you asked to express an opinion on whether there was a universal custom? A universal custom?
I was specifically asked about custom and practice within UAE and the surrounding countries, which you could say Middle East, the area. I was not asked about global, universal. That question never was requested to me.
Okay. And you
So
were
it
not,
was specific to a certain region.
you were not asked to express a view on the position as a matter of English law or English market practice, were you?
I don't believe, no, that was not my mandate. Like, I think I was approached because I did work in London for 4 years, but my expertise is within this region, and the mandate was specifically to I was not asked, and I think others can do better job if it's to talk about UK, to be honest with you.
So if, for the sake of argument, I managed to persuade the judge that the relevant market practice is English market practice, you really have nothing to say on the topic, do you?
I was not requested to do so, but if there is a new assignment to ask me my opinion, it's I can express my opinion, but I tend to agree to what you say. I was not asked for UK practice.
So can I just ask you to look at page 922 of the bundle? 922 of the bundle.
I go by pages 922. Page now, really, but okay. I was just trying to locate the page, see how bad I am. Okay, now I got the page.
Okay, so at 922, I don't know if you remember this, my instructor solicitors had been asking some questions and there was a bit of difficulty getting an answer, but then you kindly did provide these answers. Can you see that in response to request number 2B2 at the bottom left?
2B2. Okay.
Having been asked what sorts of reinsurance policies you had considered for the purposes of your first and second report,
yeah,
you said that the governing law of those reinsurance policies varies, but includes the laws of the UAE, Bahrain, and other jurisdictions in the Middle East. I cannot specifically recall a claim where the reinsurance policy was governed by English law, but in my many years of experience, and in my opinion, the governing law of the reinsurance policy is irrelevant to the market practice established in the UAE, Bahrain, and Middle East of paying litigation fees and associated expenses. And you then go on to say, at the top of 923, there is a reinsurance market in the UAE, Bahrain, and Middle East for the purpose of reinsuring marine war risks. However, for the purpose of paying litigation fees and associated expenses, the nature of the underlying risk, whether war risks, hull risks, or non-marine risks, doesn't matter. The standard uniform practice is that they're paid by the reinsurer. And then, in response to the third question, or the fourth question, you said, my opinion is unchanged, whether the relevant reinsurance policy is subject to the Institute clauses and or London market wordings and or governed by English law. I do not comment on English market practice. I consider that all of these are irrelevant to the market practice in the UAE, Bahrain, and Middle East in any event. Now with the very greatest respect, I mean, this is unsustainable argument on your part, isn't it? If a reinsurance policy is governed by English law and English market practice, it must surely be relevant to consider what is English market practice.
I think that why I'm saying that, I will say it again, not from a legal perspective, from market practice perspective. Jurisdiction is evolving around the competent court, okay, and the market where the risk is located. And if the practice that reinsurers have agreed to these jurisdictions, it means they agreed to support that market according to its needs. That's where I'm coming from.
But as I understood your first report, you actually acknowledged that there isn't a universal market practice because there are cases where insurers or reinsurers exclude cover for those costs?
Exactly why this practice was established in the region, because you are absolutely right. You go to USA, why? I used to write with AIG casualty business in USA. It could be beyond control. So there are various jurisdictions in the world. So to make it proper and suitable for each market, it has to have a practice and a system where it followed. Those reinsurers who wants to access UE market, because there is non-admitted business regime, they will comply or accept to act according to that market. And that's why insurance company you see often, they insist on jurisdiction, and they insist that in many cases to follow the fortune or as original. So they get, so it gives the comfort and easy position, sleep position to insurers from their reinsurers, because if that collapses, it will make trust in insurance as an industry will collapse. So that's why every market will have its own standards, and those standards by UK, by European reinsurers, when they come to our region, they do accept these standards because they know the market need. I'm aware of the UK reinsurers by litigation, how they look at that litigation fees, perhaps loss adjusters fees. They don't look at it as an integral part of the claim. We look at it as an integral part of the claim. Why? In this case, like if you say why I express my opinion, I have ORIS. They took 100% liability over risk. And most likely, I will not be speculating, if non-admitted business regime was allowed in the UE, they would have issued the policy directly. And they were covering this company. The action taken by APIC was really for the joint benefit of both companies.
Well, can I just pause you there?
Yeah.
Because I disagree with you,
Okay.
and my client does, and I want to explain to you why. In your first report, you tried to characterize the relationship between Al Buhaira and Aris as a fronting relationship, whereby a commercial reinsurer that is not admitted has used an admitted local front for regulatory purposes. That's how you characterize it in your first report.
I have not said it's fronting, and I explained further in my response when I was specifically asked, is it a fronting? My answer, and I can give it now clearly in person, it has so much features of a fronting in terms of 100% liability, in terms of that. However, for us fronting, and that is something with the AIG, normally, not in all cases, the business is solicited by the reinsurer, but they cannot write it in that country. They need an admitted business. That's why I said it's not pure 100% fronting, but it shares a lot of features, many features of a fronting.
Well, if I may say so, it's quite the opposite, isn't it? Because it's a syndicate. It's a syndicate of 190 members, and it's not designed to make profit for external capital investors. It has actually features of mutuality.
Okay.
So it's nothing to do with, it has no characteristics in common at all with foreign commercial reinsurers seeking local fronts with a view to conducting business as if they were primary, but through a local front. It's completely different.
I honestly don't see the relevance between the two scenarios. You are talking about the setup of a company which is registered in Bahrain by an Amiri degree, and it's established company. Now it's a profit, non-profit, that's really irrelevant. It needs to generate income, and definitely if you avoid market access fees, which is called fronting fees, commission, overriding fees, you benefit from underwriting point of view. I don't see the correlation between the two scenarios you put. From an insurance person
But you-
working in insurance. I respect your law reasons, but for me, it has no.
You're not a marine war risk specialist, are you?
I'm an ACII. I've been in insurance, but yes, I'm not. I said that. But I
you
know insurance very well. It's
But
my
you do
career.
know, at the very least, that marine war risks, it's a very specialist class of business, because it's actually very difficult to procure cover or reinsurance cover for marine war risks, given the nature of the risk. And it's because of the difficulty that ARIS was first established and continues in business. It provides a service to its members, all of its members, to facilitate the acquiring of specialized marine war risks reinsurance coverage. Isn't that correct?
When it was established, I think I was not born yet, or I was not in it. But yes, I think that's the purpose. Certain markets either create pools or create some facilities to cope with their risks. I can quote, like, you have a nuclear facility for covering Abu Dhabi. You have the WPP. Yes, there are forms the market reacts jointly to achieve that purpose. I'm not in denial of that. And I do acknowledge that UK market is the largest market for capacity for war risk. That's a fact. These are facts. Yes.
Well, so ARIS, in turn, in order for it to be able to provide its service to its members, it has to go to Lloyd's and the commercial market in London to secure retro reinsurance from London, because that's the place with the capacity.
I'm aware of that, but that applies, it's a risk transfer mechanism, insurance, reinsurance, retrocession, so you spread the risk. Tomorrow you have an aircraft crash, you will find others from all over the world participating. That is true in this case, and true in the principle of insurance. I mean, that's how insurance operates, to spread the risk. Yes, that's true. I would say true.
So wouldn't there be a real problem if there was some unwritten market practice, either in the UAE or the wider Middle East, which suggested that in every situation, in every case, every reinsurer has to pay an unlimited amount of legal fees in circumstances where they will never be able to get retrocessional cover from London, given the terms and conditions of both the reinsurance and the retrocession?
That question, thank you for raising it. We raised it at AIG when we started the operation. We brought underwriters and everything. So what was the best approach is to introduce internationally recognized clauses, claims cooperation and claims control. As a reinsurer then, they need your prior consent, which lawyer to hire, what are the fees. So you control this process without destroying it. So the introduction of such clauses, we found it to be the best mechanism to control the concern you raised that a cedant might abuse, a cedant might go hayway and for nothing. So those internationally recognized clauses will put some control in this process. That's how an underwriter, reissuer underwriter, will react to such concern, valid concern you have.
So if you look at your first report at page 311, in a sense, it's the same point that you just made orally that I think you're making there. You say, of course, there are situations where parties to a reinsurance contract may wish to depart from this market practice.
Absolutely.
Now, doesn't that obviously suggest that there is not a universal market practice? Because it's a matter of contract.
Once again, I would say, and I cannot speak of the whole world, like US, when I used to visit AIG domestic in US, it's a totally, there are differences. I am talking, it's a custom, well-established practice in our region. You go and ask any broker, any insurance company that's established. where you don't want to be part of it. Let's say a foreign reinsurer would specifically say litigation fees is that. For AIG, we used to say litigation fees is applicable. Sometimes you stay silent. So, in my opinion, the market practice, if you want to depart from this market practice, there are ways and means either to control it, limit it, exclude it. You put specific language.
So the conclusion from that really is that everything depends on the specific terms of the relevant contract, doesn't it?
What I put in my reports, and it's not really just putting the reports as I'm practicing it, we always participate in litigation fees, even if it's not specifically. So exactly, you could say implied, in this market practice it is implied, unless the reinsurer specifically excluded. And in my expert opinion and honest opinion, I've been in this market for a long time, we do pay litigation fees as per our share in cases. Also, when we sought litigation fees, we do inform the reinsurer, and I've never received an objection. I would say last case I had with Swiss Re, where they said, Osama, even this policy, I'm being sued in court, in the Abu Dhabi court. This policy, because claims made policy on PI, they said this policy is not belonging to us. But I said, okay, we've been brought in by it, and we need to defend that position and to prove otherwise. Aren't you my partner? Don't you have a big share of it? They said yes, and they participated. I'm telling you exactly how it goes. I'm not talking about legality, but practice is like that.
But 2 points there. We asked you to produce copies of
No, I just mentioned
like
without names. I cannot mention.
Okay. So you've not produced any of those policies about any of the examples you talk about, have you?
I can't. Sorry.
In your report, like you just mentioned just now, you say, well, I've got experience of other examples.
Yes, I do.
But you've not actually helped us or the court by producing any of the policy documents.
I think, from your side as well, your expert opinion will understand my position.
Hang on,
These
hang
things
on.
are private, confidential. I cannot really share it in the same manner coming from any point, because these are talking about, first of all, like with AIG, I've left AIG many years ago. I don't keep copies of that. For things which is happening, which involve others, I would not, mention. I mentioned something specifically between my company and that, and it was no other reinsurers. Didn't mention the name of the account. I did because still in litigation. I still don't. I cannot reveal. So,
so in that sense, I mean,
I do object to that because it is not easy to provide these things, and that's commonly known.
Okay, but you're not a marine war risk insurer. You're not a marine war risk reinsurer. You're making a bold assertion that in every other case you've seen in your entire career, reinsurers always pay the defence costs come what may. But you've not been able to produce a single policy to show us the policy language that relates to that subject matter. And you've acknowledged that it's critical to see the policy language because the policy language may exclude it.
If the policy excludes, if the reinsurer agreement excludes litigation fees, it's a way to depart from the market practice. I'm saying that. If they want to control it, they will impose claims control. I think it's making a lot of sense. If they want to partially sublimit it, they say litigation fees up to that. If they don't say anything, they are in it with the reinsured as advice.
So let me ask you this. Your opinion that you were asked to give was the one you set out at paragraph 1.2 of page 305.
Yeah.
Now, in answering that opinion, whether or not there is a custom or market practice that reinsurers shall pay the reasonable costs of insurers in bringing against or defending proceedings brought by an underlying insured in the UAE and the Middle East. The answer there is really binary, yes or no.
What does binary mean? Sorry, English is my second
Sorry,
language.
I'm sorry.
No, it's okay. It's fine. I just don't understand what's binary mean.
When the question says whether or not there's a custom or market practice, it's really asking you to give a yes or no answer, isn't it?
Would that be a report? I mean, I have to justify, you have to give reasoning. I have to give basis.
Precisely.
Yeah.
So you need to give the answer, yes or no, and then you need to give reasons to explain the answer. Yeah. And the reasons one would normally expect to see would be things like, here's some concrete examples by reference to the specific claim circumstance and the policies, or here's some commercial reasons which are well recognized in textbooks or in judgments or in commercial handbooks, and you've produced none of that material at all. All you've done in support of your reasoning is try to draw an analogy with fronting, which this is not, and your personal anecdotal experience of subject matter that you don't have direct involvement in. Is that fair?
What subject matters I don't have involvement with? I didn't get that.
Well, marine war risk reinsurance, and you've told us that you're the CEO of a Takaful company.
Yeah, I was asked about market practice as to reinsurers. Let me answer you in a systematic way. First question was, sorry if you say it again, just one by one, it's easier to,
Okay.
so we will benefit, will help to assist the court to make the right decision. It's just to be, I'm just giving my expert opinion. I'm not saying legal or not legal, but I'll explain myself, sure. First question.
The expert opinion you were asked to address is whether or not there is a custom or market practice that reinsurers shall pay. Is that correct?
Correct. That's the mandate.
As I understand your report, when you get to paragraph 3.2.1 at page 311,
departing. That's where you depart from practice.
Depart practice.
Yes.
So you've described what you say is a market practice. If you look at page 309, if that's helpful, 309.
309, in which point, sorry?
3.1.7.
Okay.
What you say at 3.1.7 is, in your experience, one of the common market practices and procedures adopted by market participants in the UAE and Middle East in the event of a claim relates to the payment of litigation fees and associated expenses. You want to say it's a uniformly accepted market custom in the reinsurance market, whether FAC or treaty, that in the event of a claim under an underlying policy, any litigation fees incurred by a reinsured, together with any associated costs incurred dealing with the claim, will be reimbursed by reinsurers in accordance with respective shares of the risk. And then you go on to say, in this regard, unless litigation costs and associated expenses are expressly excluded or limited by a reinsurer, in my experience, such fees form part of the reinsurance claim in the absence of specific wording stating otherwise. See further below. Now, if you just pause there, what you're actually saying is that it all depends on the contract, doesn't it?
It's contract practice as well, because a contract has implied and expressed.
Okay.
So practice, define it. I am describing what is the case in our region, how it works. Like, if I talk to you about treaty, it forms part of an integral claim, even if you have proportional. When you send to the cedant the claim plus loss adjuster fees, any fees, they go in part of, it's an integral part of the claim.
But you accept that there have been and there will be reinsurance disputes between insurers and reinsurers?
Everywhere, yes.
Everywhere.
Husband and wife, insurers, reinsurers, there are always disputes.
And amongst other disputes, one dispute could be that there is in fact no underlying insurance or reinsurance cover at all because the risk is not covered or it's been avoided. That there could be a zero claim because there's no coverage for anything.
Say that again, sorry.
Amongst the other disputes between insurers and reinsurers that you could have
Yeah.
It could be a dispute as to whether or not there's even a valid insurance claim.
Okay.
So in this case, just for the sake of argument, you don't even know the details, but the MT beta disappears in strange circumstances,
Mm-hmm.
and Abnick, Al Buhaira, they have avoided the insurance policies because they say, and the judge has held,
Yeah.
that it was fraudulent misrepresentation.
Okay. I agree, but let me ask, answer in this way. They have sought declaration from the ward to award to avert. I've read the documents, the marine policy, the war, and all of this, that they will not respond to cover. My question, what was the established jurisdiction? Was this court, correct? If you don't defend it, if you don't, if you go on to this report, very interesting case, they chased where the ship was, how it was, stack hold, when it was the last time they heard the signals from it. If Abnick did not do all of this, and then the court to prove breach of warranty, notification, and all of this, and the court said, if you don't do your homework, you pay the price. Then the court said, okay, you did not prove all of these, and the policy would respond to this claim. So in my opinion, I'm stating my opinion, what they incurred was for the benefit of all parties, even more for the one who holds the highest liability, because the other party cannot go and say, this competent court, I follow the application of the English law. If this court held Abnick liable, he is liable. It's not subject to his interpretation. It's subject to the competent court decision.
Sure. So
that served.
Let me try and agree with you.
Just let me continue, sorry, because that served the interest of all, that behavior. If they didn't do that, you could not prove there was breach of warranty, a notice period. It was laid out for a long time, isn't it? You've read the report, the expert report, the signals. These costs needs defense. You cannot prove. The court will not respond to me positively if I come and say, I swear to God, this is it's not covered. I have to prove evidence, and that costs money. That takes experts. That takes legal. That's my opinion.
That seems like a very passionately held point of view.
I am not passionate. I am stating my opinion, and that's the way I talk. I'm a bit. My wife tells me to calm down. But, I'm expressing my views, and again, by all means, I'm not legal. I'm expressing what is the practice, what is the common benefit of it, and how it is worked.
Okay.
And I think insurance is to serve that.
Mr. Abdin, I've only got 6 minutes left,
Okay. No,
and we want to release you and everybody else. So can you just listen to the next few questions, and unless you feel compelled to make a speech, let's try and focus on the question if we may. Can you look at page 317? 317. You've mentioned, I think, just now that you read the judgment of the DRC court, which I think is item 10 in the list.
I looked at it, yes.
Were you shown any of the underlying material, such as that expert report you just referred to?
I've seen a bundle, yes. It's a very big bundle. I think it was shared as exhibits, everything. I mean,
Sorry, the bundle for this trial, or you've seen another bundle with expert reports?
For this trial. I mean, I was offered to read very long. I don't honestly did not study each one promptly, but I had a big bundle. I do recall some experts' opinions about the signals. I do recall seeing these things.
Okay.
I did.
And do you know why you were shown at item 4 a copy of the first witness statement of Leonard Sudagar with exhibits?
First witness
item
statement
4.
of Leon. Why? I think to be familiar with the whole case.
Okay.
I think it's good to know everything. I mean, not specifically was sent to me. It was in a bundle. I went through it, and then I.
But it doesn't look like you've been sent all the documents in the case, because there's some various other witness statements, for example, of Greg Hammond, that you were not sent.
Mr. Hamama.
No, Mr. Hammond, Greg Hammond.
Yes, I think I've read it. I went through it at the beginning before I did my first report. There were a good number. I think he had 2 statements, if I'm not mistaken. And also I read witness statements, Mr. Hamama, and then the second witness statements. I've read a lot. Quite honestly, I've read a whole bundle of documents. Now, the lawyers would know what documents they should share with each one. I'm not aware of.
In terms of the judgment, do you realise that in the judgment of the DIFC court, the judge was dealing with 2 different policies, a hull policy and a war risks policy?
I noted that. Yeah, briefly, yes, I did.
You briefly noticed that?
Yes,
And we understand that the hull policy was reinsured by various international reinsurers who are not ours.
I'm not privy to that, but I think ORIS does not do conventional marine, and normally you'll have subscribers, reinsurers.
Okay.
Yes, I don't know exactly what is Buhaira's setup in that.
You don't know that.
Yes.
But if on your thesis, what Al Buhaira did in the court to protect reinsurers and defend reinsurers against their liabilities, they were doing that on behalf of both the hull reinsurers as well as the war risk reinsurers, weren't they?
I would think so, and they obtained declaration for both, right? They managed to secure a good, a favorable decision by the court for the hull and for the war.
So can I ask you to look at paragraph 4 at page 314 of your witness statement, your expert report?
Yeah.
314. Now, I'm not really sure why you even volunteered this conclusion, because this is a conclusion of law for the judge, and it's not even the issue you're asked to address. So we will argue about the admissibility of this. But can I ask you this? How can you justify your statement at paragraph 4.1, knowing that there's lots of reinsurers on the hull policy who apparently benefited from ABNIC's actions?
The hull, I did not was not asked about the hull because it was ABNIC and ORIS versus ORIS. Claimant is ABNIC and defendant is ORIS. My statement, I apologize, of course I'm not a judge. I know my role here is to provide my expert opinion, and for sure whether I say it or not, it's the judge's decision to make a judge. I can say my opinion that they are entitled. My opinion is not binding, it's just my opinion. Just to clarify that point, because I'm not really trying to make judgment, nor I'm in a position to make judgment. I'm in a position to give my opinion. Second thing, any reasonable cost, non-recoverable cost, which served to avoid, avert, or limit that claim, that's what my opinion states.
Okay,
they are entitled for.
But I just want to understand then whether
Because you are telling me I'm acting like a judge, I'm not.
Well, the conclusions you've expressed without even being asked to.
Because I'm not a legal guy, I'm giving my expert opinion.
Okay, you were asked about custom or practice, but what you've now said in your conclusion is that ABNIC is entitled to be indemnified by ARIS under the reinsurance contract on a 100% basis for all the litigation fees and expenses incurred during the process of defending the claim submitted by Horizon, which includes the reasonable and necessary steps to protect both ABNIC's position and that of ARIS, starting the claim in the DIFC courts. Such steps were taken ultimately for the benefit of ARIS, who'd assumed 100% of the risk under the underlying policy. And then you discuss about whether or not they'd limited the language in the cover note at 4.2. And at 4.3, you say, in my opinion, the denial by ARIS to indemnify ABNIC is contrary to well-established market practice. In fact, constitutes a breach of a well-established known and following customary practice, which serves to maintain the credibility and stability of the insurance and reinsurance industry in the UAE and the Middle East.
Absolutely.
Now, just to be clear, are you still sticking with the proposition at 4.1 that ARIS should pick up the entire 10 million dirham tab, even though on your analysis, the other reinsurers on the hull policy have benefited from this?
I have not got into, I was not requested to as to the amount, but the net incurred, see, this subject to a lot of discussion. they can recover. If they win the case, they can recover some of the money they incurred. Now, you end up, what you have incurred for this case in protection of OIRS, say you recovered from Horizon that much, whatever, I mean, you recover. That net incurred, they should not profit from it. That net incurred was served to protect both interests, and mainly, moreover, the interest. My language, I apologize for it, Your Justice. I meant not to make a judgment, I'm just expressing my opinion. Based on what I was asked about market practice, APNIC versus OIRS, I said they are entitled for that based on the market practice. It's not like I'm making a judgment.
But I'm going to suggest to you...
Because I feel a little bit heated about this. You're telling me I'm making a judgment. I'm not.
I'm going to suggest to you, with respect and out of... It is hardly
Respect
polite,
is there
so
always.
please forgive me, but,
Yes.
but I'm going to suggest you've misunderstood your function as an independent expert witness, because you've adopted a partisan position with a view to arguing the case on behalf of Al-Buhaira.
With due respect, I've been in the market in leading position for more 30 years, in leading positions. I have no reason but not to express my professional opinion, whether it is accepted by the court or not. I'm a person who will give, I feel that, that word is a bit heavy on me, partisan. I just stated my opinion. I stated what I have seen over 30 years, what was doing, and so I choose to not accept that.
Can I ask you to look at
expression.
page 343, page 343. Can you look, please, at your paragraph 2.8 at page 343?
Two?
So paragraph 2.8,
okay.
paragraph 343, you put in a report by way of reply to David Williams' report, and you said this: I note that Mr. Williams opines on the applicable governing law and whether custom and practice in the UAE are relevant where a contract reinsurance is governed by English law.
Yeah.
It appears to me that this strays beyond what we, as independent experts, have been asked to opine on in this case, as we've not been asked to give an opinion on whether English law or UAE law applies, or whether UAE customs or practice will only be relevant if the contract is governed by UAE law, or if they will be relevant if the contract is governed by English law. Now, is it you that wrote that passage?
Yes.
Okay.
It is.
So you are arguing the case again on behalf of Al-Buhaira, criticising Mr. Williams for himself supposedly straying beyond the permitted function of an expert witness to give properly qualified independent opinion evidence.
No, the point I raised, because we were specifically asked, or I am under the impression, we were specifically asked to comment on the practices. And for me, I was asked on the UAE and the surrounding country, UAE, Bahrain, Middle East, MENA region, whatever you want to call it. I gave that opinion. He pushed it that it's subject to UK. That's where I objected. My assumptions, my opinion is based in UAE, in the Middle East, in the MENA region. That's how we practice it. I was not asked, and I could have answered what jurisdiction, what this. I did not comment. I cannot say. Based on the market practice, I said APNIC is entitled. So just to explain myself.
Okay.
That's why I raised.
Did you ever see the judge's order that gave permission to give expert evidence to the parties?
I looked at it. P31, I think, right?
Sorry?
P31, or what is the question again? Sorry. My role as an expert opinion.
Not the practice direction. That's probably you're probably referring to the practice direction.
Yes.
No, I was going to ask you that there's an order that the court made about expert evidence, where the parties were allowed to secure expert witnesses. And can I just, did you ever see that order?
I honestly don't recall. I have full knowledge of it. But,
So can I just
explain it to me?
Just ask you to look, please, at Page 74. Page 74.
74, okay. Ah, RTC, okay.
Can you see that there's a heading expert reports? And the paragraph talks about the parties having permission to rely upon expert evidence from the field of reinsurance as to whether or not there is a customer market practice that reinsurers shall pay the reasonable cost insurers in bringing against or defending proceedings brought by the underlying insured in the UAE and or in Bahrain and the wider Middle East region and or in England.
Yes, at the beginning I've read that when I was sought to...
So it seems to me that you were criticising Mr. Williams for dealing with a position in England, but that was what the order contemplated could be done.
If I offended them, I apologize. I meant no harm, but
Fine.
I'm saying my comment was that it is, he made it as it is that's what I understood it, that he said it is subject to UK, and that's why.
Okay. And
Perhaps, he can accept, I don't mean any...
in terms of Bahrain, can you think of any other war risk reinsurance company established in Bahrain that provides the same service that Aris does?
I'm not aware, quite honestly. I don't think GIG does. I don't think so. But in UAE, companies are bigger. Some of them do offer. But
Okay.
in Bahrain, I have no knowledge.
Okay.
I cannot comment.
Thank you very much, Mr. Abdeen, and thank you to the judge
Thank
for
you.
tolerating
Thank you.
my time.
Nothing, my lord.
No. Mr. Abdeen, thank you so much for coming. You are free to go. You don't have to brave the traffic down Sheikh Zayed
No worries.
tomorrow.
Thank you. Thank you, Judge.
Thank
Thank
you.
you.
Okay, in terms of timing, tomorrow we only have two witnesses, I think.
We have Mr. Hamama followed by Mr. Williams.
And I suppose the two of you would like to use the rest of the day if we finish early, if you're doing your submissions.
Absolutely.
So, would you like to start at 10 or earlier?
10 o'clock will be fine.
10 o'clock is fine for me.
Okay, good. In which case, I will rise until 10 o'clock tomorrow morning.